you are welcome to ask me.
Sir, we are live on YouTube now.
We have started the program. I have admitted everybody in the program.
Rahul, I have finished the waiting room permission. So now you'll not have to, admit each and every person.
Thank you, sir.
We may have Shri A.R. Dave, Supreme Court Judge, amongst audience. If you find, please greet
sir,
him.
Sir, please
sure, sir.
repeat the name.
Dave, sir. Dave, sir.
Shri A.R. Dave and Shri K.G. Bansal. Kindly see my WhatsApp message.
Yes, sir. I'll look into it.
Right. Yes.
PK Das, member IT CBDT, also wanted to join. He says
Sure,
that
sir.
if there is no meeting, I would like to chip in and join the meeting.
Sure.
So if he wants to join, I would request you to kindly permit him.
Sure, sir.
Sure, sir. Sure.
Sure, sir.
PK Das, same way I spell my name, Das, D-S.
Okay, sir. Rahul, you please
Hanji.
start the proceeding.
Good afternoon to all the members who have joined us for the program today. We have with us renowned speakers Ashwini Taneja ji, Amit Khemka ji, and Dr. R.N. Das ji. I'll request Pradeep Goyal ji, our Vice Chairman of the branch, to give a welcome address to them, sir. Pradeep, sir.
Thank you, Rahul. Good afternoon, members. It's my pleasure to welcome you all, and learned speaker and participants who have joined us for today's webinar. We are having gracious presence of our CA, Ashwini Taneja ji, our learned speaker. Ashwini Taneja ji is an ex-ITAT member and now practicing as an advocate. We are also joining by Sri Amit Khemka ji, who is a practicing advocate, having versatile experience of dealing cases in Benami law and PMLA at various high courts and Supreme Courts. Today we have with us Dr. R.N. Das ji, who was a former acting chairman and member of Appellant Tribunal under PMLA. I hope today's session will be fruitful to our audience. With this, I hand over this session in the beginning to Dr. R.N. Das ji to proceed with his deliberation. Thank you, sir. Please, Das sir.
Good afternoon, all of you. It is nice of you to ask me to join Pipin here. So these are, as all the countries all over the world are struggling with the coronavirus epidemic. The chartered accountants know the financial institutions are experiencing enhanced compliance related issues, challenges, and those linked to the outbreak. While this disruptions is agonizing for many, but this trouble in the financial market has created new opportunities for criminals to launder illegal funds. Accordingly, central banks, including our RBI, financial institutions, are adjusting their anti-money laundering program approach to account for new patterns of criminal behavior and to better address emerging money laundering risks they are facing. So, I wanted to speak about this a couple of minutes or so, because all of you will be required when you start your auditing for this period, you will be faced with a similar kind of a situation and what to see and what not to see. What are the changes in the behavior that FinCEN in USA has noticed of late? That people are withdrawing much cash world over, huge cash at that. People are using increasingly mobile apps like nothing before, because it was so much that this sharp increase of cash withdrawal and also cryptocurrency transactions are accompanied with digital banking, particularly by elderly people. So much increased volume of digital transactions are taking place that transaction data are so huge for every country, whether it is in North America, in Europe, or India, or anywhere, that it makes difficult to banking institutions, financial institutions to discern what is potential legal transaction and what is illegal. Legal. So, what are the things that are taking place? People are selling fake cures. The crimes those are happening and to earn money. To fund fake charities, many new websites, large number of websites have come up. Then people are eliciting funds, representing as if they represent the government. So many companies, firms, vulnerable because of the financial difficulties, are becoming willing prey to launder money of these people. So new money mules are emerging. How they are doing? A money launderer poses as a legitimate medical charity. It is a genuine case I am relating. They are legitimate medical charity. They are employing people abroad, all over the world, online, to attract huge donations. And they are asking the money mules, their representatives, to receive in their own account, create account, return your commissions, and then transmit the balance to the main perpetrator. These emerging types of crimes and money laundering trends would be present in all transactions that would take place from the month of December onwards. So last financial year and this financial year, when you will be called upon to audit, you have to keep your eyes open and discern what are the transactions about. Even our Reserve Bank of India last Monday, this Monday, has added a new section in the master circular for KYC regarding PML risks evaluation, and that is in view of these things. And what is happening in India? Similar things, fake sell to state governments and hospitals, increased cash transaction, huge smuggling of gold in West Coast, and several websites have blossomed. So I wanted to say this because in money laundering matter, the criminals are always ready to avail any opportunities that may come up before them. So this is even a situation like this, when it offers an opportunity, they are also using it. And similarly, in all financial market, financial crimes, on any crime that is being committed, is committed, was committed, will be committed, its purpose is to profit out of that crime. And the profit out of that crime is usually laundered in the financial market. That is why it becomes very necessary for people like the chartered accountants mostly to be the front runners in checking this sort of crimes. And of course, we have a money laundering law, and about this, Mr. Ashwini Taneja will, and in also Benami law, about both the laws, Mr. Ashwini Taneja will apprise you at a great length, and in between, if there is anything that is where I need to supplement, I'll also contribute. Thank you very much.
Thank you, sir.
Thank you, sir. I will request Ashwani ji to please start his deliberation.
Thank you, the Lucknow branch, Rahul Bhai, and everybody else, Ravish Bhai, Goel Saab, everybody over there, that even in these tough moments, you have buckled up and taken out your valuable time to enlighten the audience and to give us a platform so that we can do mutual learning. Because what I have understood from my elders, from the saints, is that in tough times, it is your dhyan, it is your samadhi. If you read Shastras, you'll agree with me that only that can save you. So for us professionals, this is a kind of dhyan when we do learning and mutual learning, that too mutual learning. तो ध्यान या संगत वो एक ही बात है. तो किसी भी तरह से हमारा ध्यान लगे, तो जब ध्यान इधर लगेगा तो वो जो भी समस्या चल रही है वहां से ध्यान हटेगा, ऐसा मैं मानता हूं. और वहां से ध्यान हटाना इसलिए आवश्यक है कि तभी हमारा जो राइट अलाइनमेंट है वो तभी बना रहेगा. So I applaud this great noble cause which you have taken up, and I thank all the participants for sparing your valuable time and to enable all of us to make it a wonderful session by your keen and enriching participation. So friends, Benami law, you have taken that topic, which is very one of very favorite topics of mine, and we have the benefit of presence of Shri R.N. Dash, who has been at the epitome of dealing with the subject while he was acting as chairman of Benami law and PMLA tribunal. And otherwise, probably nobody mentioned that. I would like to mention it. He has the opportunity to work with Dr. Manmohan Singh, Shri P. Chidambaram, and Shri Pranab Mukherjee, all three of them. So his, great experience benefit we will all get. Welcome, Rajesh Goswami ji. Thank you for joining us today. And then we have the company of my guru, Shri Amit Khemka ji, in the world of legal jurisprudence, because he is an ace, I would say, lawyer whom I have seen arguing in the court in civil matters, in criminal matters, and art of lawyering, especially art of cross-examination. If anybody wants to learn, I think there cannot be anybody better than Amit Khemka ji. And today, since he's super specializing in this laws, prosecution aspects of laws dealing with economic offenses, so on our request, he agreed to spare his valuable time. I think all those issues which I will not be able to cover up with regard to the prosecution aspect, I think those will be lucidly covered by Amit Khemka ji. And our esteemed friend, also another ace lawyer, Shri Rajesh Goswami's presence also makes this session, I think, complete. And thank you, all of you, for joining the session. So friends, last session we had discussed about the fundamental aspects of Benami law. So with your permission today, I will not be touching the fundamentals, or not, even if we touch only a little bit, then that will allow us to have time to touch the advanced issues or the practical areas which are troubling most of us as in our personal capacity, or also when we are representing the cases of our clients. So therefore, let's begin our tour to understanding and appreciating the complex issues and practical aspects of Benami law, and also its interplay with other laws, how it affects greatly. So friends, so first of all, I would share a few basic things before coming to the, yes, I wanted to show this slide. These chimpanzees were attached by the Enforcement Directorate. I'm sure you must have noted it when you read a few months back, Times of India, or probably it was in Hindustan Times. So attachment of chimpanzees by Enforcement Directorate? not any wildlife protection authorities? I mean, I was amused to see this news for once. So what is a connect? So I have put this slide only to convey this message that now the connect of ED or the agencies like that is too wide. I mean, the connect goes beyond our imagination. So the connect is like that, that if you see the under PMLA, anybody who has done any scheduled offense, and if he has earned any proceeds of crime, he can be roped into money laundering, as offense of money laundering, if he has generated some proceeds of crime and portrayed that money as good money. So similarly here also the things happen like that, that Wildlife Protection Act is one of the scheduled offenses, and doing any violation of Wildlife Protection Act constitute a scheduled offense. So it being part of the entries mentioned in the scheduled offenses. So since the gentleman who got these chimpanzees, got the custody of chimpanzees, he did some forgery, created some documents by forgery, and then since he did some forgery and also did some violation of Wildlife Protection Act, so therefore both of them were scheduled offenses under PMLA. So offenses were committed, and the second condition fulfilled was that he generated proceeds of crime by way of procurement of these chimpanzees. So ED has been given power to make attachment of proceeds of crime under Section 5 of PMLA. So that is how the ED got the power to make attachment of these chimpanzees. So kindly see, the connect is so wide now. Chimpanzees attached by ED, and then ED handed over back to the zoo authorities. Now you would have noted this report in the newspaper that Modi's Benami law has companies running for cover, confiscated Benami assets worth rupees so much crores and all that. Then infra companies who have created land banks, etc., also in trouble. So because of their opaque structures as alleged by the Benami law department. So infrastructure companies, listed companies, public servants, private citizens, many of them have been roped in under Benami law. Then this other news I wanted to share, it was in Hindustan Times, that CBI ED action may now follow IT default props. In fact, the message is that the three agencies are coordinating among themselves as well as using the power of higher order data analytics. The concept of data analytics, now it is, I think, it is now clear with most of the persons, because you must have noted that the Donald Trump won elections on the basis of this concept, use of technology of data analytics only. So it is a quite popular technology being used now. So the government is willing to use this technology now, data analytics, so that these three agencies can work in coordination. Now, all these things I wanted to show you just to convey one thing, that number one, on the one hand, three agencies are working in tandem, 3 or 4 or 5, maybe SFIO also working with them, maybe some other agencies whom we cannot name immediately. So they are working in tandem, number one. And number two, on the other hand, the legal framework which has been created before us is such that it has got strong interplay between all the laws with each other. So each of the law has got strong interplay with each other. How? Some of the bit we will try to understand today. For example, I have shown this slide. It will show that Benami law has been put in the central condition. It is because of the fact that whatever violation in other laws will be done, Benami law will assume a central position because of the reason that most of the transaction will be done in other names so that the violation could be done. Or in the process of doing violation in other laws, some Benami transactions will happen. So Benami law element will be there in most of the cases. And the question will arise whether there is going to be a mutually exclusive situation, meaning thereby action under one law will prevent the action under other law, or there is going to be cumulative effect, meaning thereby if tax has been levied, tax has been paid by the person on one thing, and then simultaneously the Benami law will also come into action. So on the one hand, Benami law will come into action. On the other hand, income tax department will also levy the tax, and the person can also be doing, can roped into the offense of money laundering because of commission of offense of money laundering. So let's try to understand all those things, friends. So Let me take you first to some of the other essential things before I come to the aspect of interplay. The slide to show that most common ingredient found in violation of laws related to economic offenses will be Benami. Vice versa may not happen. Then, though fundamentals we have already covered, but there may be some new members who may have joined it today. Now, suppose there is, what is the concept behind Benami law? If you want me to ask in one line that how can I summarize the entire Benami law in one line? The fundamental thread of Benami law is based on this concept when the duality is created. Now, duality in the sense when the ownership is bifurcated into two parts. So one gentleman, one person will be enjoying the legal ownership, will be possessing, having the title ownership, legal ownership, we may also call, and the other person will be enjoying of the same property, the real ownership, by way of enjoying the beneficial ownership rights. So full controls, beneficial rights, enjoyment rights will be with the another person, say whom we call as beneficial owner, and the legal title ownership will be with another person whom we call it as Benamidar. So with the help of this slide, you will be able to understand better that beneficial ownership makes the payment of the consideration to the seller. Seller is B here and beneficial owner is A, and Benamidar is C. So transfer is titled to C, and the beneficial ownership is retained by Mr. A, but the consideration has been paid by Mr. A to the seller. So two conditions need to be fulfilled to put a transaction into the regime, into the realm of Benami transaction, and that is the consideration should be paid by the so-called beneficial owner, and the beneficial rights should be enjoyed by the beneficial owner, whereas the legal title should be with another person whom we may call as Benamidar. So that is where the concept of Benami transaction, execution of Benami transaction pitches in. Now, the factors, the reasons why Benami transactions are done, it could be numerous, it could be innocuous, unwillingly may have been done for emotional reasons. But the research shows that most of the cases, Benami transactions happens because of violation of land reform laws, say Urban Land Ceiling Act. Suppose a native cannot buy land, only a native can buy land in a particular area, outsider cannot buy, so outsider takes help of the native, makes him Benamidar, etc., etc. For example, things happening in Maharashtra. For example, the first case of the country, popular case of the country is attachment of Alibag property, not Mannat property, Alibag property of Shah Rukh Khan. My views were also reported on that in Economic Times, wherein I had said that somebody asked me, the correspondent asked me, how would you summarize this new law? I said, new Benami law is like unguided missile, unwittingly created and loaded with nuclear arsenal. So within 2-3 years, you would agree with me that whatever I stated way back in the beginning of 2017, it is proving to be true. So other reason could be tax evasion. A person wants to make tax evasion, he ropes in other people. Say, for example, he ropes in some other names, does transaction other names, then creation of black money. Then somebody wants to play fraud on creditors, wants to get rid of the assets in his name, then other corrupt practices. There could be, long list. As I said, there could be some innocuous reasons, some emotional reasons, etc., etc. So leaving it at that stage, let me move further, because today we are discussing the complex situation of the Benami transactions. So mostly the Benami transaction has been divided into 4 parts, in fact. That the definition has part A, part B, part C, part D. Definition is contained under section 2.9, and 2.9 has part A, part B, part C, part D. Part A is very classical class. I mean, what I mean to say is most of the cases will fall in this class. And normally we understand Benami transaction with the help of class A only. That is where property is transferred to or held by Benamidar, and the consideration is paid by beneficial owner, and property is held for the benefit of the beneficial owner. This is what we have just understood. Then the part B says where properties are held in fictitious name. For example, name of deity, name of pets, name of goddess, name of some person who is not recognized as person in the eyes of law, especially in the eyes of Benami law. Then we have part C, which says that if the owner is not aware of the ownership or denies the knowledge about the ownership, so in that case, that property straight away will be treated as Benami property. Yes, many questions must be arising in your mind. Many ifs and buts are there. There would be provisions on the way of proving Benami, like provisions of Indian Evidence Act, like section 91, 92, section 101, 102, 106, etc. of Indian Evidence Act. Then part D, where pair of consideration is not traceable or is fictitious. Under these circumstances also, it can be treated as a case of Benami transaction, and property may be treated as Benami property. Then only these exceptions are given. So meaning thereby, somebody asked me that, Mr. Taneja, whether there is any scope of mens rea. The question is that if the Benami transaction has been done without any ill will, so without any specific reason, so then whether still Benami law will be applicable, property can be treated as Benami. So sir, that is where I say that part A, part B, part C, part D, if anything falls in that, it will be Benami, except that if it falls in any of these 5 exceptions. And these 5 exceptions are: if the property is held of the HUF in the name of Karta, if property is held in the fiduciary capacity in the name of trustee, partner, director, executor, etc. If property is held in the name of spouse or child. Now spouse means what? Because somebody was asking a very interesting question, because this Benami law is, giving different kind of shiverings in the spine, different kind of tensions. Somebody is tense because of the fact that his Benami property is not detected and discovered, and somebody is worried because of possibility of discovery of his Benami rishta. So as the tensions come, similarly comes the emotions and the questions. So somebody from the audience asked me a question, ki, okay, Mr. Taneja's spouse is all right, but who's the spouse? So I said, don't be so excited. In law, it is clearly mentioned that it is his or her spouse. And then the next question comes, child, any child means, so not all those things which you might be thinking. Any child, the question is, any child means child up to what age? So the question is, the answer is that child up to any age, because for a parent, child is child. Then the next exception is if the property is bought in the name of brother, sister, lineage, attendant, descendant, or ascendant. But in this clause, unless there is a joint ownership, you will not get the benefit. And power of attorney cases, where the transfer of property has taken place, but the name has not transferred. And but it is, there has to be 2 conditions to be fulfilled. Number 1, the power of attorney holder should have paid the consideration, should have paid the stamp duty, and the contract of power of attorney should have been registered. And third condition is the original owner should remain the original owner. So, and there is one more condition with respect to each of them, that the payer of the consideration should make the payment out of known sources. Now, the legislature is not using the word declared sources or disclosed sources. It is using the word known sources. We can discuss in detail, and that is what we are gathered here to understand the meaning of these complex words and expressions which have been used in the legislation. So authorities, broadly, these 5 authorities are there: initiating officer, approving authority, adjudicating authority, appellate tribunal, and administrator, about whom we have already discussed. Then we have the IO has been empowered to seek assistance from the other authorities. So the law has been drafted in such a fantastic fashion that the IO has been empowered to obtain the information, to gather the information on pull mode as far as push mode basis. So meaning thereby pull mode means he can take inquiry information from any of the central government or state government officer, and they are duty bound to furnish. Push mode means if these authorities come to know about any Benami transaction, then these authorities are also duty bound to furnish the information to the Benami law officer within 60 days. Jurisdictional Benami law officer means the officer of the BPU. Then let us come back to that now, complex issues. Fundamentals, again, I have refreshed. So meaning of the expression known sources. What do we mean by the term known sources? Now, friends, this expression has been used for the first time in contradistinction to the word disclosed sources or declared sources. So if the words would have been declared or disclosed, that means disclosed to the income tax department, disclosed or declared to the income tax department on which tax has been paid. That would have been the meaning. Now, known means it has got nothing to do with the income tax department, number 1. Number 2, that has got nothing to do with the payment of tax. So that means what is required is that the knowledge of the sources. Known sources means something which can be described, something which can be known to the person and to the others. That is what the generic meaning of the word known can be, because no specific meaning has been assigned in the act. So if we go by the generic meaning, something which can be described can be something which can be known. Of course, unless some objection is raised against it. So if apparently something logically can be understood, that is known. So I think known, I would take it to this extent that if a person is paying check, then he should say, check I have paid from so and so bank account and outsource so and so source, say from salary, from say business payment, etc. And I think that will be sufficient for being put into the definition of known sources. Now, fiduciary capacity, because section 29A gives benefit of the keeping the asset into the fiduciary capacity. So many persons were asking me, sir, what do you mean by fiduciary capacity? And to what extent we can derive the benefit? You would recall that Indian Trust Act had few sections like section 81, 82 and 94, which allowed Benami transactions to happen, that a person can do Benami transaction. And this Indian Trust Act was enacted in 1882. And similarly, Indian Income Tax Act 1961 had also one section, that is section 281A, which allowed Benami transaction to happen. Any person can do Benami transaction, subject to maintenance of some transparency. But the issue arose that whether the Benami transactions are troubling in the economy. So therefore, keeping in tandem that law was enacted in 1988 on the recommendation of the Law Commission, and Benami transactions were prohibited in toto. And all these sections of Indian Trust Act and section 281 of Income Tax Act were repealed, meaning thereby endorsement or permission to do Benami transaction was withdrawn by the law. But section 88 of Indian Trust Act, which provides fiduciary capacity definition and keeping the asset or doing the transaction in fiduciary capacity, that was not withdrawn. So that is how I say that Benami law still recognizes the concept of fiduciary capacity, and is more so when a specific exception has been carved out if any transaction has been done in fiduciary capacity. Now, fiduciary capacity here means any trustee, executor, partner, director of a company. So meaning thereby this is an inclusive definition, meaning thereby not only these categories would be entitled for claiming the benefit, but any other capacity which law recognizes as fiduciary capacity will also be eligible to be covered here, which could be, I will give you an example. Suppose a holding company is supposed to hold 100% shares of a wholly owned subsidiary company, but because of the statutory requirement of there being at least two shareholders, one share is held by the nominee of the holding company on behalf of the holding company, whose payment is made by the holding company. So there exists a fiduciary relationship between the holding company and the nominee. So because of this saving, the nominee transaction done by the nominee will not be able to be put into the definition of Benami transaction, but for this exception only. Otherwise, it was Benami transaction straight away. So similarly, any other thing, any other situation where the law recognizes to be Benami fiduciary capacity is eligible. So fiduciary capacity relationship, whether it needs to be explicit or it can be implicit also, meaning thereby these are the explicit definitions like director, partner, and this nominee is implicit. So my understanding is it could be implicit also, this which law recognizes to be fiduciary capacity. And that is what was held by Honorable Supreme Court also in the case of Marcel Martin versus M Printer, reported in 21taxman.com/7. And section 88, as I said, it is still retained. And then let us come back to the interplay part for which many of us would have been waiting. So as you can see, I have put this Benami law into the central position. You can just have a look on the slide. So I have kept Benami law in the central position. SEBI regulations. Now, firstly, why I have taken SEBI regulations, how they affect Benami law. Now, kindly see the SEBI now and also Companies Act 2013, section 90 of 2013, which talks about significant beneficial ownership. That Ben 1 and Ben 2 has been introduced. The companies have been made now duty bound that they have to report who is the significant beneficial owner of the properties. So meaning thereby the company is required to report that if shares are registered in the name of say Mr. X, but the real owner behind is say Mr. Y, then under the reporting requirement in form BAN 1 or BAN 2, the company is required to give information to the ROC. So here the question arises, any such situation can be roped in under Benami law also? Yes, we have to think and analyze, and answer may be yes. Now, there are various situations which are given. Suppose a person is in concert with other person, acting with other persons, is holding the shares, and shares are held, say, in the name of XYZ, and XYZ are acting in concert with each other. There could be situation whereby Mr. B is acting through X, Y, and Z and holding the shares. So X, Y, Z are holding the share, and B is acting through them to hold the shares. If the reporting requirement, if the report is like that given by the company, then there are pretty good chances that B can be declared as beneficial owner and X, Y, Z as Benamidar, because section 29A will be squarely applicable under such circumstances. So situation can be cumulative. The moment reporting is done, then the action as per Companies Act, whatever it will be, and action under the Benami law will also be ready. Then let me take another example of some other law, say, for example, money laundering. So under money laundering, if a person has done the offense of money laundering, PMLA, one of the most, disaster, what should I say, most worrisome law. Why I'm saying very law, because the consequences who may have done, may or may not have done any of the offense of money laundering. But if a person has done any transaction with the person who has done money laundering, even the experience of any such person is quite harrowing nowadays. So how the relation between the two can be established? Though there are certain distinctions between the two, and the similarity is the power of attachment is given immediately to both the departments. Now, wherever a person is doing offense of money laundering, meaning thereby portraying bad money to good money, if a person does like that, meaning thereby suppose a person has earned money from tainted sources, so tainted money he has. So if he portrays the tainted money as untainted money, he does the offense of money laundering. Though now the recent amendment is saying that mere earning of the untainted money itself will amount to concept of money laundering, definition of money laundering, and as defined under section 3 of PMLA Act 2002. But the people are saying that so far that the concept of money laundering envisages that the conversion of tainted money into untainted is also essential. Suppose so if person is converting money from untainted to tainted, so tainted to untainted, in that process there is a strong possibility that he is doing transaction in some other names. Suppose a person has done smuggling, and suppose he earned a sum of rupees 10 crores, and after rupees 10 crores, say he disclosed entire sum of rupees money, 10 crore rupees, in his income tax return, and so no violation has been done because he has earned smuggling, and he has done smuggling, and he disclosed full amount of money and then paid taxes thereon. But suppose out of this 10 crores, I am taking classical case only, before the amendment was made in 1st August 2019. Suppose out of his 10 crores, 2 crores he discloses in his income tax return, say, as showing as income from consultancy. And out of rupees 8 crores, say 5 crore rupees he give to B Limited, say his name is R Limited, say his name is Mr. R. Mr. R gives rupees 5 crore to B Limited, and B Limited gives checks in the form of share capital to Mr. R Limited, which is the company of Mr. R, wherein Mr. R is major shareholder and his family. So under these circumstances, what are the, and balance of amount of rupees 3 crores, suppose he sends abroad, say Hawala, through Hawala route, to be deposited in his bank account, which is not disclosed in India. So let us evaluate the possible violation which may have taken place here. So first violation is straight away income tax violation. First violation is that he has committed scheduled offense of smuggling. So he may be punishable under IPC, relevant provisions of IPC or Customs Act, etc. Then second violation, what he has done is, say he has suppressed and evaded income tax by showing only rupees 2 crores and remaining 8 crore he siphoned off. And then he commits the act of money laundering because he converts entire 10 crores from tainted money to untainted money. 2 crores he shows as consultancy income, and rupees 8 crores he converts into other channels. So offense of money laundering is also clearly done, and proceeds of crime is this entire amount which is liable to be attached. Then he has also done the offense under FEMA by sending the money abroad. Then he has also done the offense under Black Money Act because he is having a bank account which is lying abroad, which is not disclosed. So under Black Money Act, this account is also a property which is on which he is liable to pay tax. And then he has, of course, done a Benami transaction by giving the money of rupees 5 crores to Mr. B, to B Limited, and B Limited has invested the share capital. So one school of thought says the B Limited is holding shares in Benami capacity. So B is Benamidar of those shares, though there is some other school of thought. So under these circumstances, that is how the strong interplay of only one transaction, but giving rise to different causes, because he has doing other transactions in the form of giving money to others and converting it, and thereby he is doing other violations simultaneously. So if you closely see, it is not one violation. In fact, he is doing bundle of violations. Then if we focus on income tax again, so the first, there are three, four issues which are mostly arising. So most popular issue here is section 68. That if addition is made under section 68, then what will happen? Few questions have been asked. Shri Pankaj Agrawal ji is asking if Shri Pankaj Agrawal ji is same Pankaj Agrawal ji who happens to our guru. So sir, I would not be able to answer your question, but of course I will be able to give my thoughts on this. And Amit Gupta ji has also asked similar question, probably which can be answered on the basis of this discussion which I am going to make. So friends, if addition has been made under section 68, say for example, let me take one practical example and from there we will proceed further. A person made surrender during the course of search, say rupees 25 crores. And the breakup of the surrendered amount also included a sum of rupees 10 crores. The name of the gentleman is Mr. R, and he is major shareholder. He and his family is major shareholder and director in R Limited, their company, family-owned company. So 10 crore rupees is the bogus share capital which has been received from B Limited in the account of R Limited, and R Limited has issued the shares to B Limited thereby. So he made surrender of that. He paid tax on that, and with the understanding the matter is over. Taxes were paid. So the next, before he could have taken a sigh of relief, within few days, notice comes from the BPU, that is Benami Prohibition Unit, asking for recording of his statement under section 19 of PBPT Act 1988. So he goes for the statement. So during the course of statement, he straight away asked for the question, you have made a surrender? Now he raises his collars up. Yes, sir, I have made the surrender and I have paid taxes also thereon. Okay. So that means you are saying that surrender amount includes sum of rupees 10 crore received from B Limited into your company R Limited. Yes, sir. So that means you received check from B Limited. Yes, sir. And therefore, from that means when you received the check from B Limited, before that you have given cash to B Limited. And in lieu of that, check was received by Limited to R Limited. Now silence prevails and he is not able to say no. So he says yes, or answer is taken as yes. So if answer is taken as yes, then the IO proceeds further. So you receive check cash, you give cash to B Limited. B Limited gives check to R Limited, and R Limited in lieu of that issues share certificates to B Limited, and B Limited is holding shares in its name. So now the question arises whether the shares are held in real capacity or Benami capacity, and some Benami transaction has taken place or not, and if yes, what? And then what is the assets which are liable for attachment? What IO does, he holds the entire transaction as Benami transactions. He makes attachment of these shares. He makes attachment of rupees 10 crores lying in the bank account of R Limited. So now friends, question here arises whether the IO's action can be said to be unjustified. Now there could be two schools of thought. First school is saying that here straight away transaction is Benami transaction, because admittedly the shares held by Mr. B are held in Benami capacity. He is not the real owner. However, the assets lying in the with R Limited are not Benami assets, because R is an independent company and the assets have been acquired by the company in its own name, in its own control. R is a separate legal juristic person. But of course, the shares held by B Limited are Benami, and real owner is R and B is Benamidar. Now, another school of thought says that the shares are mere paper mere papers. These are dues, do not represent any real value. They are not property, so represent any actual real property. So therefore, there is no question of happening any Benami transactions. One school of thoughts also says that assets lying in the books of R Limited would also be Benami, and that will be Benami because ultimately that is the underlying asset. So these three schools of thoughts are there before us. Now, to be very simple, if the facts are very clear that cash has exchanged hands, in my considered opinion, the shares will become Benami property. Though somebody may say that shares need not be made Benami property because no asset is existing. But my respectful submission here would be that the property is existing. The real owner of the property may not be B, but the shares are valid. Shares can be transferred. If a person wants to transfer the shares, if there are takers available, shares can be transferred, and the transfer of the shares can be enforced unless any other illegality is pointed out therein. So shares do exist. So it will be a very, very difficult situation. So there may be a cumulative effect that on the one hand, taxes may be paid by that gentleman. On the other hand, it may be roped into Benami law. The situation is tricky, though there are gray areas, though I also am not 100% clear on this. So with due respect to Pankaj, his thoughts may be different and his thoughts may be same, I do not know. But law is evolving and it will take a lot of time for law to evolve. That is how in the beginning, these are the thoughts which we are giving. Then secondly, implications under section 56 to 10. Suppose a person makes a gift. A gifts a property to B. Now, there could be two situations. Either the gift is genuine or the gift is not genuine. So if the income tax officer treats the gift as genuine and makes addition in the hands of, say, B on account of some lower valuation or higher valuation, etc., under section 56 to 10, then Benami law officer cannot come into picture and cannot say, no, I will treat this Benami transaction, real beneficial owner is Mr. A only. No. And vice versa is also true. Suppose this transaction is treated as non-genuine and Benami law officer says, no, this is a Benami transaction, A is the beneficial owner, B is simply Benamidar, so therefore I will attach the property. Then its addition under section 56 to 10 cannot be made by the income tax officer. Here it will be a mutually exclusive situation. Then GAR. Under what situation, if provisions of GAR are invoked or PPT are invoked to deny the treaty benefit, and then what could be the consequences? In one case, what happened, probably the name of the case is AB Mauritius, and the ruling was given by authority for advance ruling. And the brief facts were something like that there was one US company who wanted to make investment into an Indian company, but it made investment not directly, but through Mauritius route. So what it did, it created a company M in Mauritius, and company MCO, made investment in shares in Indian company, that is ICO, and UCO remained the parent. So during the course, it was held by the authorities that this MCO was not the real company. So the real parameters were not fulfilled of the treaty. So treaty benefit was denied because MCO was not acting as a real beneficiary. So since treaty benefit was denied, then in next year, probably the matter reached in authority for advance ruling. So authority held after making detailed discussion that company M, that is MCO, is in fact a paper entity. It does not have any control. Entire control is held by U company, that is US based company. It is discharging all the functions. It is giving the instructions, and company has no role at all whatsoever. So therefore, the treaty benefit should be denied. And the PPT test was also invoked, principal purpose test. So if treaty benefit is denied, what could be the consequences under Benami law under these given facts? Now, one of the situations could be that somebody may say that it is an international transaction and PPT Act does not extend to international transactions. Friends, you would be right, but right partly only. The PPT Act does not extend to properties located outside India, but it does apply to property located in India, even if any transaction has been done by non-residents, whether irrespective of the fact whether Benamidar is non-resident, beneficial owner is non-resident, both of them are non-resident. Even then it can apply so long as other conditions are fulfilled. And other conditions here would be that US company is a real beneficiary, M company is just the Benamidar. So Benamidar is holding the asset. So this asset which is held in India, that is shares held in ICO, are Benami assets. So these shares were attached by the initiating officer. So that is how the interplay can work in this direction also. And in this slide, I have explained this, how it has happened. You can see it for a moment. Of course, under these circumstances, burden of showing that the transaction is Benami, it would lie upon the IO. There is no doubt on that. Then this I have already discussed, that significant beneficial owner, how and under what circumstances there can be a parallel application under SBO concept and as well as under Benami law. Then burden of law, burden of proof. Under any litigation, friends, the burden of proof is a very, very important aspect. One of my favorite topics is also art and skill of representation. And if someone asks me that, Mr. Taneja, how can you summarize in one line the whole art and skill of representation? Then I would say, and my attempt to summarize in one line would be that understanding the art and skill of representation is understanding the game of burden. Whose burden is what? When this burden can be said to be discharged and when not. When we can understand this whole concept, this very concept, we can understand and take into control the whole art of understanding the art and skill of representation. So here, coming back to Benami law also, though it looks to be similar to income tax law, but believe me, there is nothing common between income tax law and Benami law except one thing, and that is the enforcement agency is common, and that is income tax department. So since enforcement agency is common, it appears that everything else seems to be common. But believe me, the fabric, the thread on which this with which this Benami law has been woven and this income tax law has been woven are different. And basic distinguishing thread is burden of proof. Because under the question arose under Benami law, whose burden is the primary burden? Whose burden is to prove it any transaction or property is Benami? So since this is a recent law, nothing specific has been mentioned therein. The IOs started taking a stand that the burden is of the noticee. So that is how they were issuing the notices. So that is how I say that while representing before the initiating officer, you have to keep in view that concept. Because if you will remember this concept, you will properly represent there. Now, not in the Benami law, but under civil law, these matters reached up to Honorable Supreme Court. And these two judgments, P. Lilavati and Mangathai Ammal, Honorable Justice M.R. Shah recently gave judgments, and wherein it was held that the burden of proof is upon the person who is alleging that so-and-so transaction is Benami. Because under civil disputes, there were disputes on ownership claims. So it was held that, and there were other judgments also, many judgments are there on this. So it was held that the burden to prove is upon the person who is claiming it to be Benami. So when we quoted this judgment before the initiating officer, they said, no, those were in the context of civil law, now PBPT Act has come. I got a privilege to argue this matter before the appellate tribunal, before Honorable Justice Manmohan Singh, and he gave very detailed and very well-reasoned judgment in the name of Srimati Pamela Bhardwaj and Ramneek Singh Kochar versus initiating officer, wherein he took help of these judgments and held that yes, under Benami law, the concept is well defined. The burden is upon the person who alleges it to be Benami. So here, IO is alleging it to be Benami. So burden to prove will be upon the initiating officer. Now, what are the consequences of the Benami transaction? Consequences under the law. The very first consequence with which we get acquainted or we face is attachment of the Benami property or proceeds thereof. So both property can be attached. If property is not available, then proceeds can be attached. To my mind, both cannot be attached simultaneously. So proceeds will be attached only when Benami property cannot be attached. And Benami property will not be attached if it is sold and proceeds are available. And even if proceeds are not available, but Benami property has been sold to a bona fide purchaser, nothing can be attached. If proceeds can be attached, all right. Then with the held with the bona fide owner, no attachment. That is my considered opinion. Then subsequently, if it is finally held by the appellate tribunal that this so-and-so property is Benami, then confiscation proceedings can take place before the adjudicating authority, and confiscation may also take place. Then second thing is, which will be in detail covered by Amit Khemka ji, that prosecution with rigorous imprisonment of the person who is found to be guilty and fine up to 25% of fair market value. And then prosecution for false information is also there. I request Amit Khemka sir to please take it up all these things in detail. Then there is one other penalty, section 54A recently introduced. Sir, kindly cover up that also for non-appearance or giving not information to the initiating officer. I'm leaving it for Amit Khemka sir. Then provisional attachment. Provisional attachment can be done by the initiating officer under section 24(3) for a maximum period of 90 days from the issuance of show cause notice. Then after this period, we attend before the initiating officer, and if the initiating officer is the opinion that yes, provisional attachment is still this property is in his opinion Benami property, then initiating officer can continue the provisional attachment order till the adjudication by the adjudicating authority, which will be done under section 26(3), and for which 1 year time limit is prescribed. So broadly speaking, the time limit for provisional attachment is around 1 year 90 days. Plus minus 15 days and plus minus 1 month for issuance of notice and all that, etc., etc. So you may say around 14 or 15 months, you can see maximum period of provisional attachment, after which either it will be confirmed or its property will be released. If it is confirmed, then the remedy available is for filing of appeal before the appellate tribunal, whose chairman has been our own respected Shri R.N. Dash, whose presence benefit we are getting today. Then, friends, in fact, provisional attachment cannot be done on whims and fancies of the IO, but in none of the cases, IO is fulfilling these conditions. So, in fact, the IO is required to make proper reasoning if he has to give recorded finding that the property is likely to be alienated, and also recorded finding the property in whose possession the property is currently is held Benami, and then obtain prior approval. But IO is not fulfilling all these conditions in accordance with law. Then the next question which arises before us is, what is the effect of attachment? Enjoyment of property come to an end, or only right to transfer the property becomes restricted? Very important question, in fact. How the attachment has been defined. Attachment means the prohibition of transfer, conversion, disposition, or movement of property by an order issued under this act. And section 57 says, notwithstanding anything contained in the Transfer of the Property Act 1882 or any other law for the time being in force, where after the issuance of notice under section 24, any property referred to in the said notice is transferred by any mode whatsoever, the transfer shall, for the purpose of proceedings under this act, be ignored. And if the property is subsequently confiscated by the central government under section 27, then the transfer of the property shall be deemed to be null and void. So, friends, if this is the situation, so if we make combined reading, this section and this section, the immediate message we get is restriction is on the transfer, nowhere on the enjoyment. And in generic sense also, the attachment means attachment from transfer. So it is not sealing of the property. It is sealing and attachment are both different, not freezing of the property. It is thus attachment. So attachment means attachment on the legal tides, on the transfer effect. And so enjoyment of the property can be continued. If the tenant is there, tenant will continue to remain there. You are getting rent, you will be continue to get the rent, etc., etc., etc. But you cannot mortgage it, because mortgage, if it was not mortgaged, you want to mortgage, then you are creating some ownership rights, distinction in ownership rights, which may not be allowed. Transfers, if shares are transferred, shares are attached, whether restriction on right of voting, restriction on right to participate in shareholder meeting, restriction on right to receive dividend, restriction on to pledge shares, restriction to sell, transfer of shares. So again, the question answer is same. So since the right of usage is not attached, so therefore all those things rights will be available. Only right to transfer will come to an end. Restriction on right to pledge shares will come to an end. Every other right will be there, should be there. Right to sell would not be there because it is transfer of shares. So first 3 rights will be available. Last 2 rights will not be available, according to my understanding. And this is precisely what was held by Honorable Supreme Court in the case before you, that is Balkrishna Gupta and others, versus Swadeshi Politics Limited and others. Then this I have already discussed with you, that subdivision, etc. This wherever transfer is involved, that will not be allowed. Then confiscation. As I have said, the confiscation will take place only after the appeal is decided by the appellate tribunal. If a person does not file the appeal, then the confiscation proceedings may take place forthwith. If a person files appeal, then once the order is decided by the tribunal, only thereafter the confiscation proceedings can begin at the adjudicating authority level. Then protection to the bona fide purchaser. This is very, very important issue, but not properly drafted under the law. Any innocent buyer of the property, why should he suffer? So to claim his protection, Section 27 says that he has to fulfill these three things. Number one, he has paid adequate consideration. Number two, he has to buy property prior to issuance of notice under Section 24(1). If he buys subsequent to that, no protection, irrespective of anything, irrespective of any violation of any fundamental right, etc., nothing doing. Then third, the purchaser had no knowledge of the Benami transaction. If he had knowledge, no saving, then this property is able to be attached, because the property will be said to be held Benami in his possession, and Section 24(3) will be straight away applicable. So whose burden is to prove that three conditions are fulfilled? This is also very important question, and fortunately we got to argue this matter before the appellate tribunal in the case of Vargo Township and Kavita Infrastructure, Vargo Township from Jaipur and Kavita Infrastructure from Pune. And in both the judgments, Honorable Tribunal has held that so long as the requisite facts are available on record, the burden will be upon the initiating officer that these conditions are not fulfilled. If I have paid by stamp duty is paid through register date, then unless IU proves that consideration is not valid or not adequate, it will be deemed to be adequate. Similarly, IU has to prove that I had knowledge of issuance of knowledge of the Benami transaction. So burden in that case, because I cannot negatively prove that I had no knowledge of Benami transaction. So that is how burden was put upon the shoulders of the IU. Then this is another cardinal issue. Another cardinal issue, whether initiating officer can disregard provisions of Section 91, 92 and Section 101, 102 and 106 of Indian Evidence Act on the ground that provisions of PBPT Act 1988 has got overriding effect. Friends, though provision has got overriding effect, but overriding effect only in those cases in case anything contrary is mentioned in PBPT Act. So long as nothing contrary is mentioned, PBPT Act is also offspring of Constitution of India as Indian Evidence Act is. So therefore, both the acts will, like siblings, have their respective effects. And since they will have their respective effects, both will have their play. So the cases will have to be decided, taken into view the provisions of these provisions of Indian Evidence Act also. Whether IU has power of arrest? No, thankfully no. PMLA officers have, ED has? Yes, they have. So that is the distinction between PMLA and here. Income Tax Department has? No, they do not have also power of arrest. So power of arrest only with ED, neither with BPU nor with income tax officers. Power of survey, search and seizure, it does not have, IO does not have power of survey, search and seizure, but it uses BPU as its hands to do searches and survey and search and seizure. Writ jurisdiction. Writ jurisdiction can be invoked only when palpable injustice has been done against a person, which can be proved without going into the facts, where the charge is apparently proved on the face of it, and where the accusations made or where the action done of attachment by the Benami law officer is such that even if the facts narrated are taken as correct, still that action cannot be taken, and where no alternative remedy exists. This is also one of the criteria which is taken by the higher court sometimes. So only in these extreme cases only writ jurisdiction should be invoked. Otherwise, unnecessarily matter will be got stuck up at High Court. Some adverse observations can come from Honorable High Court, and matter will be sent back still to the IO or to the file of the adjudicating authority. So only in sparing cases, very deserving cases only, deserving cases only, writ jurisdiction should be invoked before the jurisdictional High Court. Then this I am skipping for the time being. Then this I will be taking NRI. Some people are asking, sir, upon the NRI also this law can apply? Yes, sir, it can apply. If the transaction is something like that, NRI friend has purchased land, taking help of his Indian friend, and if these facts are revealed that Indian friend has just lent his name, he is not the real owner, then the property being located in India, that land located in India can be attached, that Indian friend can be treated as Benamidar, and that NRI friend can be treated as beneficial owner. His prosecution may not take place immediately until he comes to India, but friend in India may be in trouble and land here will be definitely attached, and other consequences may also follow, which Amit Khemkaji will dwell upon. Then offense of money laundering. So friends, with regard to offense of money laundering, I will be very quickly covering up, though Dasab is here, and He will add if anything more is required. In fact, in the offense of money laundering, 3 things are required. As I said, that stage 1, there has to be commission of scheduled offense. Stage 2, there has to be generation of proceeds of crime. And then stage 3, commission of money laundering by placement, layering, integration. Now, recent amendment has been done, which is tending to suggest as if the moment money is earned and proceeds are generated, it amounts to money laundering, though which it shakes the very foundation of the legislation with regard to money laundering, that is PMLA. But so my mind that the stage 3 is also essential, but you kindly take it into consideration. Moment scheduled offense is done and some proceeds are generated, it may amount to offense of money laundering. Then friends, since we have the benefit of presence of Amit Khemkaji and RN Dasar also, so it is good if I take some questions quickly instead of taking more time on anything else. So friends, I think we can come back to the question answer session quickly, and back to the organizers to take up question answer sessions, please. In the chat, questions are there. So I will begin from the first one. Please switch to slideshow view. Okay, I have done. Prem Prakash ji, please arrange PPT. Okay, please arrange PPT for both the sessions. Please arrange. A company gifted a piece of land to a person without consideration and registration of land executed. Land to a person without consideration and registration of will it be Benami property? Sir, as far as gift is concerned, if you have gifted, no problem. But the problem is lack of पूर्ण समर्पण. आप पूरी श्रद्धा से तो हम कुछ काम करते नहीं, अगर गिफ्ट दे दिया तो दे दो, फिर ऑनर अपने आप को ऑनर नहीं दिखाओ. So if gift is executed, gift is accepted in the law to the subject to the conditions whether a company can gift, whether it was possible in its by way of its memorandum or articles, etc. If it is made possible somehow, no problem. Gift is given, and the person whom gift is given, that person is enjoying the property, no problem. The situation should not be the gift, the property is lying registered in some other name, but benefit continues to be enjoyed by somebody else. Then voice. The next question is, so any other question, friends? If you have, then I will take up. Otherwise, I will request the organizers to give the forum to Khemka sir and Das sir. Maybe from live session, some questions you might be getting on the chat, because here on the Zoom only limited questions have come. On the live chat, if you have, Rahul Verma ji, Ravi Chaudhary ji, you can come switch on the video for a few minutes and share. Hemant Kumar ji is asking, a property purchased jointly by A and B having share property specified is 80% and for A and 20% of B, but consideration is paid by A is 30%. Yes, sir. In fact, similar situation happened in one of the cases from Bhopal, where there was a dispute on ownership and payment. So if it does not fall in one of the exceptions, then a person who has paid 30% should be owner of 30% only. If he becomes owner of more amount and if he enjoys the benefit of more amount, there may be a problem. So kindly be careful that as much payment has been made, so much should be the percentage of shareholding in the property. Then Gopalji Nigam is asking, if someone is issued but no provisional attachment was done, if is owner free to sell? Yes, so long as property is attached, so long as property is not attached, you are free to sell. But you will have to disclose the facts to the buyer that 24(1) notice has been issued, because the moment you issue 24(1) notice, section 51 says the transfer shall be null and void. So since transfer is null and void, you are not legally entitled to make transfer of such properties. So kindly be careful while doing this illegal transaction. Yes, sir. Next. at later stage D transfer the balance property to B. Okay, if he transfers, all right, but though section 6(1) is there, which bars that no Benami property shall be retransferred, but for the time being, at least you make these corrections, it will be good. Then somebody was asking, two brothers have jointly acquired a property and their ownership ratios are disturbed. That somebody say a person, one brother has paid less, acquired more, other brother paid more, acquired less. So as far as brothers are concerned, since they fall in exception clause, whereby joint ownership, if they are in joint ownership, then it will not be Benami. So therefore ownership ratios will not disturb them. Probably we had asked that question. So that is answer to the question. Atul Agarwal ji is asking whether there is any time limit for passing an order by the IO after submission or reply from the person to whom summons issued under section 19. Sir, fortunately or unfortunately, section 19 does not have any time limit. Time limit starts running only after issuance of notice under section 24(1) and not before that. So no time limit. And that is an unfortunate part in the law. And that is how on the lighter side I say कि साहब बेनामी लॉ में जो लॉजिक हैं वो उस लेजिस्लेशन से लिए हैं जो 5000 साल पहले आया था, जिसका नाम था श्रीमद् भगवत गीता, जिसमें उन्होंने कहा है कि द टाइम हैज नो बाउंड्रीज, समय अनंत है, ना इसका प्रारंभ है ना अंत है. तो जगह जगह समय से बांधा ही नहीं. सेक्शन 19 में कोई समय सीमा नहीं है, रेट्रोस्पेक्टिविटी की कोई सीमा नहीं है, प्रोस्पेक्टिविटी की कोई सीमा नहीं है. आज आप ट्रांजेक्शन करते हैं, पता नहीं कितने साल तक, चिरकाल तक आपको वो नोटिस इशू कर सकते हैं. Then sir, Kamal Agrawal ji is asking if Mr. X or X Limited transfers some amount in his employee Mr. A account and land is purchased on the name of his employee, and after that one collaboration agreement takes place between Mr. A, Mr. D and landowner X Limited. Sir, these complex cases will not be possible to discuss here, but one thing I will be sharing that कोई भी आप ट्रांजेक्शन कर रहे हैं, आपने अपने एम्प्लॉय के नाम से ट्रांसफर किया, ऑल राइट, फिर एम्प्लॉय ने एसेट खरीदी, नो प्रॉब्लम. बट द प्रॉब्लम विल बी कि जहां जो जैसा कर रहे हैं वैसा होगा नहीं. आपने अगर एम्प्लॉय को दिए हैं कोई पैसे, तो या तो आप सैलरी में देंगे, या आप लोन में देंगे, या आप गिफ्ट में देंगे. इन तीनों में से कोई चीज होगी. एम्प्लॉय जो शेयर जो एसेट खरीदेगा वो अपने राइट में खरीदेगा, नो प्रॉब्लम. अब आपने इस तरह से दी अमाउंट और एम्प्लॉय जो एसेट ले रहा है उसका बेनिफिशियल एंजॉयमेंट और कंट्रोल और डोमिनियन इज एक्सरसाइज्ड बाय यू, देन देयर इज अ प्रॉब्लम. एज आई सेड इन द बिगिनिंग, Benami law is based on the concept where there is a concept of duality. Legal ownership and beneficial owner is bifurcated. Benami law comes into motion. Then Amit Kumar Gupta is asking, I have asked through mail about EMI. Sir, I said no problem about EMI, etc. between the brothers. Because of the joint ownership concept, there will be saving. So the moment आप joint owner बन गए, आप 100% owner बन जाओ, आप सिर्फ 1% के ओनर बन जाओगे, प्रॉब्लम ही नहीं है, क्योंकि जॉइंट ओनरशिप की रिक्वायरमेंट है. जॉइंट ओनरशिप कितनी होनी चाहिए ये नहीं लिखा उसमें. एंड देन few 4 new messages. Sir, he is not a joint owner. If he is not a joint owner, there is a problem. You said that they both are the owners. If there is a joint ownership, then you will not be able to get the benefit of the saving. So saving will be only when joint ownership benefit is there. Please unmute. Who's saying unmute? I am unmute, sir. Acha, probably, Amit ji is probably asking himself to be unmuted.
Okay. With your permission, sir.
Yes, sir. Yes, sir. You can unmute. Anybody can ask. Only request is only those questions which can be asked to maintain the grace of this forum. Kindly ask those only. And please do not bring out complex facts. Question should be issued.
Sir, I request you also please share a number so that if members are required to ask you some complex question, they can directly ask you.
Okay.
Amit Kumar Gupta. Amit Kumar Gupta. I would also request members to please raise your hand so that it will be easy for me.
My number is given in the slide which I have just opened. So my number and email address, both are available there.
Amit sir, yeah. Amit sir, you, yes, please ask a question. We can hear you.
Yeah, thank you. I had mailed, I had done the whole thing in mail also. I had written the two brothers are not joint owner of the property, but major part of the AMI has been paid by second brother only, and he is claiming the tax benefits also. That was the question. So if there are some flaws in this, so how can he? Basically, these are the modes जो कि छोटे शहरों में लोग करते हैं इन जनरल की फादर के नाम से लोन ले लिया और किस्त जो है बेटा पे कर।
जॉइंट ओनरशिप करके करें विद इन द फैमिली। जब तक कि वो वाइफ और चाइल्ड वाली कैटेगरी नहीं है तब तक जॉइंट ओनरशिप से ही करें, अदरवाइज देयर इज गोइंग टू बी प्रॉब्लम।
और एक्चुअली प्रॉपर्टी जो है वो बैंक में प्लेज है तो वो कोई करेक्शन भी नहीं ले सकता टिल देन जब तक वो लोन रीपे नहीं हो जाता। और इज इट पॉसिबल टू डू समथिंग?
चलिए फिर आप बेटर टू इग्नोर इट एट द फॉर द टाइम बीइंग देन।
ओके,
ऐसे पता नहीं कितने ट्रांजैक्शन होंगे, गॉड नोस हाउ द गवर्नमेंट विल बी हेल्पिंग।
हाँ एग्जैक्टली, मतलब these are number of the transactions।
बेनामी लोग की खासियत ये है, जो है सो है, जो नहीं है सो नहीं है। नो इफ्स एंड बट्स, नो कांसेप्ट ऑफ रीजनिंग, द रीजनेबल कॉज, नथिंग लाइक दैट। है नहीं है नहीं। जी सर, नेक्स्ट क्वेश्चन इफ एनी, or I should hand over the mic. Do we have the presence of Shri KG Bansal sir or Shri AR Dave sir? If you can unmute yourself sir, and I would like to, the audience would like to say hello to you sir.
No, they are not there.
KG Bansal sir or AR Dave sir?
No, they are not there.
Priyansh was coordinating with them.
No, they are not there.
No, sir, they are not here.
They are not in.
Pardon sir, can I interrupt?
Yes please.
सर इन दिस, मतलब जो क्वेश्चन मैंने आपसे पूछा था, अगर उस केस में जो सेकंड ब्रदर है वो डायरेक्ट लोन अकाउंट में पे ना करके,
ब्रदर मोबाइल नंबर ले लो, कॉम्प्लेक्स केसेस वाले जितने।
अच्छा श्योर
okay, you are always welcome.
Sure, no issues sir। Okay,
so sir, can we sum up and hand over the mic back to you?
Sure, sir.
Thank you.
Thank you, sir, for this lovely presentation and deliberation. So we have with us Amit Khemka ji. So not wasting more time. Thank you, sir. We are going directly to the Khemka sir. Khemka sir.
Okay.
You're audible, sir. You're audible.
I was not able to unmute my mic.
Yeah. Sir, now you're audible.
Good afternoon, everybody. It is always a pleasure to have august company. We have Honorable Shri R.N. Das ji, Honorable Shri Ashwini Taneja ji as on the dais, and the organizers, the chairman, Mr. Verma, the other organizers, Chaudhary Saab, and other senior members of the Lucknow branch are also there. I really thank you all for giving this this platform to me to talk to my fellow colleagues and fellow professionals. What has been happening since the time liberalization in economy took place in 1991, that as the government liberalized the economy, there were people who tried to take benefit by finding loopholes in the system and use them for their own monetary benefits, which resulted in the government coming out with more and more laws on the economic side, on the fiscal side, to cap such wrongdoings, and which has resulted in many amendments being made in Income Tax Act, the the promulgation of Benami Properties Act, promulgation of Prevention of Money Laundering Act, promulgation of Black Money Act, coming out with a totally new Companies Act, then coming out with IBC. So these are all various laws which had to be brought out. And most of these provisions, rather, if I may say, all of these laws consist of provisions which are related with, which make certain wrongs as prosecutable wrongs or criminal acts, for which apart from the penalties and fines, even very harsh provisions are there for the purpose of punishing the people with heavy imprisonments. Now, all these laws involve commercial angle. All these laws involve economic angle. All these laws involve fiscal angle. And when these prosecutions, when these prosecution cases are to be handled in the court of law by lawyers like me, who are not chartered accountants, or who are not as expert as you people are in this field, we of course find it very difficult to undertake these assignments, without the help of the chartered accountants. In most cases, which we handle and we are handling, we have asked our client to involve their chartered accountants so that we have the benefit of a team which can handle these prosecutions. But what I have found, I don't want to get into the blame game, but what I have found that there was an angle which I saw, that as if the chartered accountants had the attitude that although the provisions of prosecutions are contained in the income tax law, Income Tax Act itself. Chapter 22 of the Income Tax Act deals with the prosecution provisions, as if they don't exist for the chartered accountant, as if they are not concerned with them. And we found that what should have been done at the stage of making replies or filing replies in the penalty proceedings. They did not know that there is a prosecution provision. There is something like prosecution. Therefore, there was hardly any consciousness about it. And this inspired me to talk to people like you. I have been talking to many chartered accountants almost all over India now. I have talked to chartered accountants, of course, in Delhi NCR, in many of the of your gatherings and many of your platforms. And I've talked in Bombay, Chennai, Hyderabad, and other places. And what I found that I was right, that the chartered accountants did not pay any heed to the prosecution provisions. And therefore, it is necessary that these prosecution provisions are known to the chartered accountants. Normally, I start with some of the provisions of Income Tax Act. Today, we don't have too much of time now because but I will try to take you through the important provisions and some of the provisions which are utilized in day-to-day and which are where we get lots of cases. So before that, what I'll do is I'll start with the prosecutions of the Benami Act, as the Ashwini sir has left it for me, because that becomes my duty. So please enable my so that I can share my screen. Please enable it, Mr. Chaudhary.
Sir, you can share the screen.
नीचे bottom पे आ रहा होगा sir, bottom पे scroll करो. थोड़ा सा बॉटम पे स्क्रॉल करो, आ रहा होगा शेयर स्क्रीन.
No, no, I know that, but it is coming host disabled attendee screen sharing.
ओ राहुल जी फिर आपको करना पड़ेगा.
एक सेकंड बस, एक सेकंड, आई एम डूइंग इट. सर प्लीज ट्राई नाउ. अभी हो जाएगा सर.
Okay, yeah, I can do it now. So I'll begin with the PBPT Act itself, and then I'll go back to the other provisions. The definition of what is Benami transaction has already been taken up by Ashwiniji in detail in many of his deliberations. And I will straight away come to the prosecution provisions in PBPT Act. Section 3 of PBPT Act which existed even in the 1988 Act and made it a criminal offense.
खेमका सर आपका वीडियो नहीं आ रहा है.
Neither video nor audio.
वीडियो आपका जो पीछे स्क्रीन शेयर किया है वो विजिबल नहीं है. ऑडियो आपका आ रहा है सर.
ऑडियो तो मुझे नहीं आ रहा.
शायद ऑडियो भी नहीं आ रहा क्योंकि हैंग सा हो गया लगता है.
ऑडियो मुझे नहीं आ रहा है.
सर जब तक खेमका सर का टेक्निकल इशू हम सॉल्व करते हैं तब तक हम दास साहब से कहेंगे कि वो प्लीज कुछ इनपुट दें.
ओके.
कैप्टन का होने का एडवांटेज यही है कि सेल द शिप कीप सेलिंग.
No, about this Benami Act. Benami Act came in the year 1988. So the same year, the another act that came also, the Prevention of Corruption Act 1988. It was both of them, those were Rajiv Gandhi Act. So, but one was not, Benami was not implemented. The Prevention of Corruption Act 1988 was diluted for quite some time. So, the known sources which Asudiji was referring to is a hangover of Prevention of Corruption Act. In section 13 of Prevention of Corruption Act, the known sources of income is defined. There is an explanation to section 13 where it says known sources of income means income received from any lawful sources of income, and such receipt has been intimated in accordance with the provisions of law, rules or order for the timing in force since it was meant for public servants, it was meant for public servants.
दास साहब,
But
just sorry to interrupt sir.
Yes.
खेमका सर के साथ प्रॉब्लम, टेक्निकल इशू हो गया, इंटरनेट का कुछ प्रॉब्लम हो गया है. सो इन मीनवाइल आप यहाँ पर हैं, इससे बड़ी हम लोग के पास कोई एसेट नहीं हो सकता है. So please continue, sir. Whenever he will come join us, I'll intimate.
Whenever he comes, till that time,
Sir, can we take questions also, sir? If
I'll be very glad to take questions on Benami, money laundering, and Ashwini ji is also here, so we will be able to try to answer as many questions as possible.
Great, sir. So members, I request you all to please raise your hand if you have any question. So will sir, Ashwini sir and Das sir will reply for all the queries.
So known sources for Benami is something that is known not to the either Benamidar or to the beneficial owner, but to the IO. So, and the burden is always on the Benamidar and beneficial owner to show what are their known sources and how they are known sources. So it is rather tough there. So this is what I wanted to say about known sources. Now we are ready to take questions.
Ravinder ji is asking, can definition be imported from other act? In the chat box, sir, if you can also open the chat box, Dex, sir. Ravinder ji is asking one question.
I should unmute Dharmendra.
I'll deal with that. We cannot take the definition from
Dharmendra sir, you are unmuted. Dharmendra sir, you can interact directly.
Yeah.
You can ask the tell me.
Sir, you are saying that known source definition is given in the Prevention of Corruption Act.
Yes.
My question is, for the purpose of Benami Act, can that definition be imported?
Answer cannot be unequivocal. It cannot be no. It cannot be yes either. The reason is why I told that when both the acts were being framed by the same sort of people in the legislative branch of law ministry in the same time, so they were probably, that hangover was there. And in any case, there are a number of cases like Jayalalitha case, where in the context of a Prevention of Corruption Act, now Khemka Saab is in, so we should welcome him back.
Thank you.
Welcome back, sir. Sir, there was a question of Dharmendra sir. Das sir was giving the reply. So I think Das sir, please complete your reply. Then we'll go back to.
Okay. So the thing is that while there is no definition of known sources in the Benami Prohibition Act of 1988, and the definition available in the Prevention of Corruption Act 1988 is limited to public servants, we cannot greatly benefit from it. But the case laws that has happened between 1988 and till date on Prevention of Corruption Act, there are a plethora of cases where the courts have decided that it is not the delinquent, the accused person, who should determine what are known to him. The known sources means what is known in public domain, in the official domain, to the government, to the prosecutor. And that view will certainly be of help to us in this case. And in any case, the burden of proof of known cases lies with Benamidar and beneficial owner. So that being the case, it will become all the more difficult for the Benamidar and beneficial owner to take any broad advantage of known sources for their case.
One thing more, Dharmendra Bhai.
Yes.
One thing more, Dharmendra Bhai, can you hear me? मैं वही सोच रहा था धर्मेंद्र जी का क्वेश्चन नहीं आया अभी तक.
Yes, sir.
I was thinking धर्मेंद्र जी. देखो इसमें एक section 231 है in PPPT. That I would read it for the benefit of the entire audience, because ये हम कई जगह we will get stuck up. Before I hand over back to Amit Khemka sir. 231 says words and expressions used herein. Herein means जो definition clause है section 2 से 21 से 230 तक. Words and expressions used herein and not defined in this act, but defined in Indian Trust Act. अब 8 associated act के नाम दिए हैं. Indian Trust Act, the Indian Succession Act, the Indian Partnership Act, the Income Tax Act, the Depository Act, the Prevention of Money Laundering Act, and the Limited Liability Partnership Act, and the Companies Act shall have the same meanings respectively assigned to them in those acts. तो अगर कोई चीज यहाँ नहीं तो हमें वहां देखनी है. अगर यहाँ भी नहीं मिलेगी तो फिर उसकी जनरल मीनिंग पे जाएंगे या कॉन्टेक्चुअल मीनिंग पे जाएंगे.
नहीं तो सर वो जनरल क्लासेस एक्ट में जाएंगे ना.
अगर यहाँ नहीं मिलेगी तो पहले तो इनमें जाएंगे हम.
हाँ, इसका मतलब है कि फॉर द टाइम बिंग वी कैन से कि प्रिवेंशन ऑफ करप्शन एक्ट की जगह अगर हम जनरल क्लासेस एक्ट में चले जाएं तो
नहीं. जब वो उसमें लिखा है कि कोई चीज जो यहाँ नहीं है वो पहले वहां जाओ आप.
तो वहां नहीं लिखा ना, प्रिवेंशन ऑफ करप्शन एक्ट नहीं है वहां पे.
नहीं है.
नहीं लिखा नहीं है.
नहीं यहाँ इस पर अच्छा प्रिवेंशन ऑफ करप्शन नहीं लिखा. यस वो नहीं लिखा.
यस
लिखा.
हाँ तो आप जनरल में जाएंगे. अब वो दैट साहब ने कहा है कि इसका बड़ा कोई अनइक्विवोकल क्वेश्चन आंसर नहीं दिया जा सकता. इट विल डिपेंड अपॉन कि आप कोई और जनरिक लोगे. अदर साइड वुड से कि व्हाई नॉट दैट प्रिवेंशन ऑफ करप्शन एक्ट क्यों नहीं लिया जाए. जनरल पे भी जब जाओ जब कहीं डिफाइंड नहीं है. सो दिस इज वेरी क्लोज टू एटलीस्ट क्लोजर देन द जर्नल. So this will be a matter of now debate and discussion. It cannot be answered unequivocally. Rightly put up. Sir Saab's
thank you.
Yes sir, summarizes the things very aptly. I am fan of him.
Thank you sir. Thank you.
Yes, sir. Now we'll hand over the session to Amit ji. Amit sir, please take over.
So I was saying that section 3, subsection 3 as it used to be, now it is subsection 2. It says that whoever enters into a Benami transaction, which means that the incidence of criminality is entering into the Benami transaction, meaning thereby that the cause of action will arise as on the date when the Benami transactions was entered into, and that is what has been made punishable by the law. So subsection 2 of section 3 deals with the transactions which took place before the commencement of the Benami Transactions Prohibition Amendment Act of 2016, which came into effect on 1/11/2016, which is more clarified by the next subsection. Whoever enters into any Benami transaction on or after the date of commencement, that is 1/11/2016, shall, notwithstanding anything contained in subsection 2, be punishable in accordance with the provisions contained in chapter 7. So all the transactions which were entered into prior to 1/11/2016 were to be dealt with by subsection 2, and all transactions which have been entered into after 1/11/2016 are to be dealt with in accordance with chapter 17, to which I will take you just now. Before that, what subsection 3 does, subsection 2 does, that it has the maximum punishment prescribed is up to 3 years and with fine. The Criminal Procedure Code provides for a limitation period in cases where the offense is punishable with imprisonment up to 3 years, and that limitation period is 3 years. So if only those offences which were which took place before 1/11/2016 could be prosecuted under subsection 2, then in that case, as on 1/11/2019, they have become time barred. So I feel that this subsection 2 has now become a kind of a redundant provision. However, now coming back to chapter 17, chapter 7. Now the first section of chapter 7 is section 53 of PBPT Act. Now this provision is applicable only after 1/11/2016, where any person enters into a Benami transaction in order to defeat the provision of any law or to avoid the payment of any to avoid the payment of statutory dues or to avoid payment to creditors. So it is like subsection 3 of section 3, subsection 2 of section 3 was in respect of all Benami transactions. It is not so far as section 53 is concerned. Not every Benami transaction, you might have the property attached for, even though there was no other violation of law, even though it was done with all the bona fide, the property might get attached. But in order it to be prosecuted, it is necessary that either of these three conditions are satisfied. Now it can be if the transaction was entered into to defeat the provisions of any law. Now any law could be, like for example, there are land reform laws all over the country. In almost every state has land reforms laws where the property purchased by certain backward castes and classes is not transferable to anyone from the other castes. Now, it is common practice that first that property is purchased in the name of one of the confidants who belongs to that particular caste or class, and then a company is formulated and the property is developed in that company and its shape is changed from agricultural to residential or commercial, and then it becomes transferable. Now that kind of transaction is squarely covered by way of this particular provision. Now it could also be where suppose the property was purchased in the name of the mother in order to save upon the stamp duty. Now that also can be said to be the purpose to defeat the provisions of any law. Now the other type of where the prosecution can take place is to avoid the payment of statutory dues. One knows that my assessment is going on, my cases have been reopened, and it is likely that additions will be made and there will be huge tax and penalty liability over me, and that person transfers that property in order to avoid that the payment of statutory dues or to avoid even the payment of creditors. Now, if either of these three conditions are there, then in that case the offense becomes the Benami transaction becomes a criminal offense and it becomes punishable under this particular section. The punishment provided is not less than 1 year and up to the period of 7 years, and also a fine which may extend to 25% of the fair market value of the property. Now question arises, who are the people who can be punished for it? It is the beneficial owner, Benamidar, and any other person who abets or induces any person to enter into the Benami transaction. So it is not only the beneficial owner and the Benamidar, but also any person who is found to have abetted or induces. In fact, after the abatement, it also uses a wider word, inducement. Now, these are the, so there are, in fact, I will say that there are 4 types of people who can be prosecuted under this section: beneficial owner, benamidar, abettor, and inducer. So it is not only the benamidar and the beneficial owner who are liable to be prosecuted under this section. Then section 54 of PBPT, this makes giving any person who is required to furnish information under this act knowingly gives false information to any authority. So he is also punishable with imprisonment, which is not less than 6 months and which could extend up to 5 years, and also 10% of the fine of the market value of the property. After this, recently by the Finance Act, the section 54A and 54B have also been introduced in this act. Now, 54A deals with a situation where the summons are not complied with or are avoided. And for every such violation, a fine of rupees 25,000 can be imposed on the person who does not comply with the summons issued by the IO to a person. Then 54B is akin to it says that how the documents, it is actually akin to 279B of the Income Tax Act, and it says how the proofs of the records and documents have to be proved in the criminal prosecution trials before the court. Now, then there is all these offenses can only be prosecuted by the prior sanction of the, earlier the word in section 55 was board. Now that has been changed to competent authority, and by way of an explanation to this section, a competent authority has also been defined, and to who is that is the director, the commissioner of income tax, etc., and under the Income Tax Act. So those now it is no more the board which is the sanctioning authority. It is almost identical to what is there in the Income Tax Act for the purpose of prosecution. Now, this is what was the prosecutions under the Benami Act, Benami PBPT Act. Friends, coming back to the Income Tax Act, Chapter 22 of the Income Tax Act deals with the prosecutions under the income tax law. I will quickly take you through these provisions. You will notice that these provisions, when I take you through these provisions, you will notice that there are 2 types of contraventions or 2 types of offenses under the Income Tax Act. One, where there is a mental state required, there is a mens rea required. But there are offenses where there is no mens rea required. Now, this particular section, which is on your screen, is one of those sections, 275A. It says that whoever contravenes any order referred to in second proviso of subsection 1 or subsection 3 shall be punishable with rigorous imprisonment, which may extend to 2 years and fine. Now, if an order has been passed under section 132, say for example, restraining a person from operating a particular bank account. Now, if the violation of that order is made, then in that case, that is punishable with imprisonment up to 2 years of period. Now, the question, there was a very interesting case of Patna High Court, in which Patna High Court gave a judgment. What happened that a particular account of the SSC was ordered to be made inoperative, but he opened another account and started making operation in that account. The department said that it amounts to contravention, but the court said that no, the contravention will only be in respect of the account in respect of which the order was specifically made. Then another offense where there is no mens rea required is failure to comply with the provisions of subclause IIB of subsection 1 of section 132. Now it says that whoever does not provide the facilities required by the authorized officer will be liable to be punished with 2 years of imprisonment. Now, this is yet another section which does not require any kind of mens rea. The question arises whether a notice under section 132 is a prerequisite for initiation of action under section 275B. The High Court of Delhi, in the case of SR Bartley Boy, gave the judgment that yes, unless there is a notice issued under section 132 asking for the required assistance, the section 275B is otious. The other issue which was also decided in this case was, and is very important for the purpose of the professionals, especially the chartered accountants. What had happened was that the department has seized certain laptops. The SR Bartley Boy, they refused to give the passwords of those laptops on the ground that there are information available of many other clients in that particular laptop, and they are not that they are entitled to privilege and to keep them confidential, and therefore the department is not entitled for a roving or a fishy inquiry. Their lordships cited a Supreme Court judgment of and where the court had dealt with a case under the Stamp Act. And this is what they said, that as the court had said that the banks are entitled to keep the documents confidential, it is our considered opinion that the same privilege of confidentiality must extend to auditors as well. This judgment can be very, very useful for the chartered accountants to see that they are not liable if a department wants to enter into a fishing or roving inquiry. They are not liable to disclose or assist in such a situation, and they will not be liable to be prosecuted for under 275B. Then removal, concealment, or transfer of or delivery of property to thwart the tax recovery. If you saw that even under the Benami Prohibition Act, the whole of section 53 deals with the same situation, but it is the same thing almost which is punishable in the Income Tax Act also. However, it is a little wider thing, only in respect of the Benami transactions, but it is if anybody removes, conceals, transfers, or delivers to any other person any property or interest therein, to prevent that property or interest therein from being taken in execution of a certificate. So, and that is also punishable with 2 years of imprisonment. I'll just skip this section and come to 276B. Now, this deals with the TDS, and 276BB deals with the tax collected by the under 206C. Now, both these sections, the punishment is not less than 3 months and up to a period of 7 years. The question arises that whether delay in deposition of tax TDS also attracts prosecution. The answer has been given by Supreme Court in the case of Madhu Milan Syntax. Prosecution under 276B can be launched for delay in depositing the tax also. Now, this is one of those sections, 276C, which under which the maximum number of punishments, maximum number of prosecutions are launched by the department. 276C1 in fact, 276C1 and C2 are two separate offenses. If you see the language, 276C1 make whoever a person willfully attempts in any manner to evade any tax, penalty, or interest, while 276C2 deals with a person willfully attempts in any manner whatsoever to evade the payment of any tax. The difference between C1 and 276C1 and 276C2 is that in the former, it is the evasion of tax, penalty, or interest per se, while 276C2 makes payment of tax punishable, tax or penalty or interest punishable. So the question not naturally arises that what is the stage when the offense can be, when the prosecution can be initiated. So far as 276C1 is concerned, the punishment can be launched even while the penalty proceedings are pending, or because, however, in a very recent circular, the CBDT on 9/9/2019 have come out with a direction that no prosecution under 276C1 shall be launched unless the proceedings, the appeal, the stage up to the ITAT has been exhausted. So now the situation has changed, although the situation earlier was that the prosecution under 276C1 and the penalty proceedings could go on simultaneously. Now, 276C2 is the payment of tax, penalty, or interest. Now, this is where the tax, penalty, or interest have become crystallized. Now, how it becomes crystallized? It could be by self-assessment. It could be by way of an order passed by any of the authorities. Now, the question is that while the CBDT says 276C1 prosecutions will not be launched till the matter has been finalized at the ITAT stage. However, when it comes to 276C2, there is no such direction which has been given, and the prosecution can be launched just after the assessment at the first stage has been completed and no injunction has been given. An identical provision exists under the Black Money Act also. In fact, the only difference here is that the punishment has been increased from 7 years to 10 years. And the minimum punishment has been increased from 6 months to, rather 3 months to 3 years. So this is the only difference in Section 51 of the Black Money Act. However, it is an identical section to 276C in the Income Tax Act. Now the question, whether the assessing officer has to wait till the completion of the assessment, I have already given you the answer. That in 276C1, it could be started, but now because of the directions of the CBDT, now it has to wait till the conclusion of the proceedings before the ITAT. There is an impression that what is punishable under the Black Money Act is only the unexplained income or asset. Now, friends, while unexplained income or asset will fall under Section 51, as I just now showed you, where the tax has been evaded. However, mere non-declaration, mere non-declaration in the returns or not filing the returns in respect of the property assets located outside India or the income from a source outside India is punishable with up to 7 years and with minimum punishment of 6 months under Section 49 and 50 of the Black Money Act. It is also punishable under 276D of Income Tax Act also makes punishable the failure to produce accounts and documents with punishment up to 1 year. A person willfully fails to produce or cause to be produced on or before the date specified in a notice served on him such account or document as are referred to in the notice, or willfully fails to comply with the direction issued to him under subsection of the, he shall be punishable with rigorous imprisonment up to 1 year. A very interesting case comes to my recollection. We are doing a case for a chartered accountant where he has been issued a notice by the department under this section. The facts of the case were that the chartered accountant was representing the SSC, and certain notices were issued under 148 and others. And in reply to that, the replies were given by the chartered accountant from his ID, as you all now have to upload or send the mails for the purpose of the filing the replies. Now, those replies which were filed had to be filed with certain documents which were asked for. By mistake of the staff, the documents which were to be attached with the reply were not submitted. The reply was filed by the chartered accountant in his own name. Now, this is the example which I am giving you because there is a tendency among the chartered accountants not to work at an arm's length with an arm's length approach. The chartered accountants know, I mean, if you see our pleadings or our documents, whenever we have to file a document in the court or any other authority, we will always say, Mr. So-and-so, the petitioner, through Amit Khemka, advocate. However, with chartered accountants, I have seen it normally that they file the reply as if they are the SSCs themselves. If you see the language, it doesn't even say sometime that these are the instructions of the client. I have been suggesting that whenever you are filing any document on behalf of the client, a copy countersigned by the client should be preserved in your records whenever you are uploading it, so that tomorrow an SSC is not able to change his statement and say that I had not said this, or I had not instructed like this. Now, false statement and verification. This is yet another provision normally which is utilized a lot by the department. Whoever makes a statement in any verification under this act or under any rule made thereunder, or delivers an account or statement which is false and which he either knows or believes to be false or does not believe to be true. Now, this is the verification. The meaning from the verification is the verification of the returns or an affidavit which is filed with the verification. Now, if any such affidavit has the contents of such affidavit or the return are found to be wrong, then in that case, the punishment is up to 7 years with a minimum punishment of up to 3 years, 3 months. In one of the cases where the SSC received a notice under 150, a search took place and he surrendered an income of about 5 crores. At the same time, he also gave a FD of about 10 crores to the department and said that whatever tax or interest is made is leviable, you please deduct it out of this FD. And the department deducted the interest and the tax. However, a notice under 153A came, and the chartered accountant went and on his letterhead gave a reply, made a submission that the returns filed under 139 may be treated as returns under 153A. The department said that you filed you made a wrong verification in the statement, and therefore the SSC was, the prosecution was launched against the SSC under this particular section. Now, there is a identical provision in the Black Money Act, which is section 52, punishment for making false statement and verification. Then comes the falsification of books of accounts. I'm just running through because of I'm already, I think, over time. Abatement of false returns. Anybody who abets or induces in any manner another person to make and deliver an account or a statement or declaration relating to any income or any fringe benefit chargeable to tax, which is liable to punishment up to 7 years and with minimum punishment of 3 years. Then Black Money Act also has an identical provision. Then prosecutions under the Income Tax Act, as well as under all these acts can be launched only after the sanction has been granted. Under the Income Tax Act, with the principal commissioner or the commissioner or a commissioner appeals. However, in the new guidelines which have now come under with the new guidelines which have been propagated by the CBDT in June 2019, have come for the purpose of compounding and the prosecutions. In those guidelines, it has been said that for the offenses where the tax penalty and interest, in the cases where tax penalty and interest is less than 25 lakhs, a system of collegium has been formulated, which in my opinion is beyond the law, and where 2 or 3 CCITs or CITs have to join hands as collegium for giving the approval for the prosecution of certain sections. But if the tax penalty or interest is more than 25 lakhs, then in that case, the sanction has to be given as per this particular section, subsection of section 279. The identical provision is there in the Black Money Act, as you can see, section 55. Now the question arises whether show cause notice is a must before initiation of the prosecutions. The Supreme Court in the case of Valiappa Textile has said that there is no requirement of a notice to be issued before the grant of sanction or initiation of the prosecution. However, department as a matter of practice always issues notices before initiation of prosecution, and especially before the grant of the sanction. The question arises as to how these notices are to be dealt with. Now, my experience is that there is an approach that at the stage of the notice, we should not give too much of explanation or we should not disclose too much of our defense. And because by doing that, we are making the department more intelligent or more aware, so that they will be able to plug those areas. My request and my suggestion would be not to have that approach. It is an opportunity to present those facts or those pleas which the department has been ignoring. And believe you me, in most of the sanctions, the department does not even look into your notice. And if you have given all those issues, if you have raised all those issues in the reply, then in that case, tomorrow when the prosecution is, when the trial takes place before the court, we can always say that this sanction was bad because my reply, the points raised by me in the reply were not even taken into account, were not even dealt with by the sanctioning authority. So it is the stage where it should be decided as to how we have to bifurcate among the issues which we want to share with the department, or which we don't want to, which we want to hold back for later. But my suggestion is that we must raise all the relevant issues, it may be not in too much of detail. It is also the stage, and which is this, I think this is the last stage when a trial lawyer should be involved. There is also a practice among the chartered accountants of giving these replies at their own end. I will say that a lawyer who deals with the criminal cases should be involved as a team at this stage, so that later on, whatever defense has to be taken during the prosecution, during the trial, it is prepared now, the strategy is prepared now. Then all these offenses, the section 279(2) says that any offense under this chapter, either before or after the institution of proceedings, be compounded. Now, the section says that every offense under this section is compoundable. However, in the guidelines issued by the CBDT in the month of June 2019, 14th June 2019 to be precise, they have made certain offenses non-compoundable, and two of the sections are 275A and 275B. My view is that this is something going beyond the law, which in my view, that CBDT cannot do. Also, while this section says that either before or after the institution of the proceedings, so which means that even till the end of the trial, when the trial is going on, the person is entitled to apply for compounding. However, now the CBDT says that a limitation period has been prescribed by way of circular of 14th June 2019, which says that the compounding application has to be filed within 12 months of the end of the month in which the prosecution complaint was filed. The strange thing is that that limitation starts running as soon as the department files the prosecution complaint. And thereafter, after filing the prosecution complaint, the department may not pursue it. The department counsel may not be present. Department may take date after 1 year, till 1 year. The notice of the complaint may not be served on the SSC, and the 12 months may pass. And still, it is a very, very, in my view, a very unreasonable way of doing it. There's a very unreasonable restriction which has been put on the right to have the matters compounded. And then, after this was prescribed, the CBDT forgot that there would be certain offenses, certain cases where there will be very little time left. For example, a prosecution complaint was filed in July 2019, and on 14th June 2019, this circular came. So the person would have hardly 1 month's time to file this application, because his period will expire in July 2019. So then they probably woke up from the slumber, and in the month of September, they came up with another circular which extended this time till 31st December 2019 as one-time measure, and then it was again extended on 4th of January up to 31st January 2020. However, now no more extension has been granted for that purpose. Now another point is that what is the relationship between the prosecution and the assessment oblique penalty proceedings? Now, whether the prosecution can be initiated even before the conclusion of the penalty proceedings, except for under 276C1, which now the CBDT bars, it can be launched even together with the penalty proceedings. If the penalty proceedings fail, can the prosecution continue? The answer is yes and no. If the penalty proceedings fail on merits, then in that case, the prosecution also has to go. But if if they fail on the technical grounds, the prosecution proceedings, the trial will not fail. Now, what should we take from it is that when the chartered accountants or the tax practitioners are dealing with the case in the penalty proceedings, and if they have a chance of winning also on the merits, the approach should be that they should win on merits as well as the technicalities. Now, sometimes we feel very satisfied that we have got the relief on technicalities, but that may not be the end of the story. The prosecution may still be launched and the person may have to suffer the prosecution unnecessarily while he had a chance of winning the penalty proceedings on the merits also. Now, Prevention of Money Laundering Act is has already been dealt with by Ashwini ji. I'll not take much of your time. But there is a question that is there or can there be a relationship between the offenses under PMLA and offenses under the Income Tax Act? How much time do I have, Mr. Chaudhary?
Sir, you may please continue. We have 15-20 minutes, no issues.
Okay. So the question is there or can there be any relationship between offense in the PMLA and Income Tax Act? You know, you are all aware that Prevention of Money Laundering Act is attracted only when the proceeds of crime are generated out of a proceeds of crime, out of an offense, which is a scheduled offense. If you can see 21U, as a result of criminal activity relating to a scheduled offense. Now, no offense under the Income Tax Act is part of the schedule of the Prevention of Money Laundering Act. So, on the first look, it looks like as if there is no relationship between the Income Tax Act and the Prevention of Money Laundering Act. But then there are issues which we have to keep in our mind. Offenses under Section 51 of Black Money Act, which is identical to Section 276C of the Income Tax Act, are in the schedule of the PMLA. So if it is a foreign asset or the foreign income or the income from outside India, in respect of which the tax has been evaded or in respect of which the tax has not been paid, that is an offense under Section 51 of Black Money Act and which attracts the Prevention of Money Laundering Act. The second case can be any fraudulent act which may attract Section 417 to 420 of IPC. And another case is of Section 447 of Companies Act. These are also scheduled offenses. Now, we are doing when it comes to 447, we are doing a case where a fraud took place in a private bank. The directors siphoned off the money by doing fraudulent transactions which are covered under Section 447 of Companies Act. Now, those directors an inquiry took place and SFIO has launched prosecution under section 447 of the Companies Act. Now, that money which the directors had siphoned off is alleged was invested in certain, was channelized through a chartered accountant who was in the business of providing accommodation entries through 9 or 10 of his companies, which were where the directors, etc., were his stooges. And that money was, after channelization, was invested in certain properties. The section 447 being a scheduled offense, the SFIO is investigating, and also the enforcement director is also investigating. Then, since the chartered accountant has assisted in providing these accommodation entries, he is sought to be made an accomplice, an abettor, an inducer at both the places. You understand that the chartered accountant who provided accommodation entries, he has committed an offense under the Income Tax Act. And he has also committed an offense under the Benami Properties Prohibition Act, which by having the Benami companies by which he transacted, he made these transactions. So these are the cases where all these provisions, all these laws are easily attractive. Any false or forged document may attract section 467, 471, 472 of IPC, which again are scheduled offenses. Now let me just take your attention to the definition of evasion of tax, which is given under 276C1. Now this is the explanation to 276C1, which says, willful attempt to evade tax for the purpose of the section shall include a case where any person has in his possession or control the books or documents containing false entry, makes or causes false entries in the books or documents, omits or causes to be omitted any relevant entry. Apart from attracting the provisions of 271 AAD, the recently added section, this particular act of making false entries or having books or documents containing false entries or omission to make relevant entries is also within the definition of forgery, my friends. Now let me take you to the definition of forgery in IPC. Whoever makes any false document or false electronic record or part of a document or electronic record with intent to cause damage or injury to the public or to any person, or to support any claim or title, or to cause any person to part with property, or to enter into any express or implied contract, or with the intent to commit fraud or that fraud may be committed, commits forgery. So you can see that the requirements for committing forgery and for committing an offense under 276C1 are the same. And whoever fraudulently or dishonestly uses as genuine any document or electronic record which he knows or has reason to believe to be forged document or electronic record shall be punished in the same manner as if it has forged the document. Now 471 is a scheduled offense. So the same act which is committed by a person which attracts 276C1 also will attract sections 471, which is a scheduled offense under the PMLA. So it cannot be said, and one should not be oblivious of the fact that the wrongs under the Income Tax Act, which may look innocuous and which may look just the acts which causing avoidance of tax or avoidance of payment of tax, may also attract severe provisions of other laws which may have very serious repercussions. In fact, I must say that even the provisions of the Income Tax Act have very, very serious repercussions, because most of them provide for minimum imprisonment. Now, I can just skip the burden of proof, but only one thing I'll just say under the Income Tax Act and the Black Money Act. Income Tax Act, I had requested you to notice that there are certain provisions which say that there is a mental state required, where it says willfully or fraudulently or with the intention of, while there are certain sections which do not require the culpable mental state. In Income Tax Act, it is an impression that only under the PMLA, the onus of proof, there is a reverse onus of proof. Friends, even under the Income Tax Act and under the Black Money Act, also, there is a reverse burden of proof when it comes to the mental state, culpable mental state. So it is 278E says that the court shall presume the existence of such mental state. So why I am showing you this is because this culpable mental state, one has to start dealing with it right at the time of the first reply which is filed in the penalty proceedings. You have to be conscious of the fact that a day will come when the court will presume the mental state and the person will become culpable. He will be prosecuted and he will have to prove that he did not possess such a mental state. Then it should not be, of course, taken that reverse burden of proof does not mean that department has to prove nothing and everything has to be proved by the person accused only. So it has been recently said in one of the cases by the Supreme Court that it cannot be understood to mean that the moment an allegation is made and the FIR recites compliance with the statutory procedure leading to the recovery, the burden of proof from the very inception of the prosecution shifts on the accused. However, the question remains that the mental state will be presumed, and the onus will be that there was no mens rea or there was no intention to commit the offense. That onus will remain on the person. Fortunately, there is no such reverse burden of proof in the Benami Prohibition, Benami Transactions Prohibition Act. Now, let me just quickly take you through the procedural part of these. All the, like in the police cases, you know that after an FIR is launched, the prosecution is, the investigation is made, and then the charge sheet is filed, which is in legal terms is called final report under section 173 of CRPC, and which becomes the point from where the prosecution proceedings start in the court of law. However, in all these acts, PMLA, PBPT, Income Tax Act, Black Money Act, it has to be started only by way of a complaint filed by the authorized officer. बंद हो गया तूने फोन लिया था क्या? Did you take the phone?
Amit sir, there are few questions also which are coming probably.
Yeah, but I'm
Your screen is stuck, I guess. Your audio is coming.
Yeah. So I'll just leave the screen and I'll continue with my audio, I suppose. I'm not able to handle it. Uh,
There are a few questions coming up. If you want,
yeah,
I can
yeah,
take up the question.
I can take the questions first. Okay, fine.
So Dharmen sir has asked few questions. I'll ask him to please come up and ask sir. Sir, you're on the spotlight. You can ask the question, Dharmen sir.
Okay.
There is a specific prosecution in Income Tax Act.
Yes.
Then prosecution in other act for the same offense will not be a double jeopardy for the same offense.
I have been discussing it with the very literate people of this line, Das sir, Dr. Rakesh Gupta, Ashwini ji, and other people, and I have gone a step further than what you are saying, Dharmendra ji. I have said that once you make the culpable mental state as presumed, then in fact you are levying the penalty as well as the prosecution on the same set of facts. So it is, in my view, it is absolutely harsh. There is no doubt about it. In fact, with the new explanation coming into PMLA, the very commission of a scheduled offense has, if it is taken literally, then very commission of the scheduled offense becomes a money laundering also. So these are very harsh provisions. They have yet to be, unfortunately, our courts are not very sympathetic to the wrongdoers, and not many people have the courage, not many clients have the courage to go to the courts and challenge the constitutionalities. They prefer, they want कि साहब हमारा तो किसी तरह से compounding करा दो, हमारे को जाने दो. So that is the approach. So maybe we will wait for an appropriate case where the Supreme Court actually considers these questions and replies.
Another thing, Amit bhai, whether the prosecution will be counted on the same thing, if say 3 years prosecution in Income Tax Act and 3 years in Benami Act, whether these 3 year will be 3 year or it will be a 6 year.
Provided the punishment is awarded, sentence is awarded in the other case before your completion of the term. If suppose a person was awarded punishment for 1 year in 2018 and the punishment awarded in another case was in 2020, then in that case it will not, because by that time he has already undergone the sentence. He might request for concurrent thing only if he's yet to go through undergo the punishment.
And one thing is whether the burden is on the person alleged or burden is the person who is suffered.
Burden on the sufferer?
Whether the person who is suffering the prosecution law.
That is why I took you to the burden of proof. What is all the factual aspects have to be proved by the department. However, only one presumption under the PML under these Income Tax Act and Black Money Act is there, and that is of the culpable mental state.
Yeah.
We have another question coming from Anshul. Sir, if your query is done, Dharmen sir.
नहीं, एक दो query और हैं.
Sir, please continue, sir.
हाँ. And one thing is, sir, you said statutory dues. Whether statutory dues is a certain tax or whether it is also uncertain tax.
I think I answered that. I actually showed a judgment also on the screen, which it is the 276C1 deals with evasion of tax. 276C2 deals with non-evasion of payment of tax. So if the evasion of payment of tax will be only when the tax is ascertained, it could be by way of self-assessment, it could be by way of an assessment order.
Okay.
Thank you.
So we have a query from Anshul.
Yes.
Anshul, can you hear me? Sir, Anshul has posted a query.
Yeah, please read it.
In the case the bank account is seized for non-payment of tax in dispute, the assessee opens another bank account to continue business transactions. The AO gets the information and seizes the same too. Can AO ask assessee restraining him to open any other account?
Somebody has answered it already. No.
You know,
Sir, I don't think the query has been answered yet.
no, not that query has been answered, but I think Das sir, can he keep on, I mean, I think he can keep on.
Yes, there is no, in fact, I don't know, we heard somebody called Katrina Kaif. We are very lucky to have today here. She answered here, she answered no. In fact, while the assessing officer can attach multiple accounts, he cannot debar somebody from opening an account. There is no, though no legal, there is nothing under income tax law that does not give him such power.
The assessing officer can impose a penalty or prosecution against the assessee as he is continuing opening another account.
No.
There's willful default.
No, Anshul, 132(1) order can only be passed in a, that is what Patna High Court says, that you have to pass it specifically. Okay. So it can't be in REM. So if he has in that Patna High Court case, he passed an order in respect of one account, the SSC opened another one. So the prosecution was launched in respect of another account.
Yes.
The court said that no, nothing doing. You can open another account because the order under 132(1) was only in respect of the account number 1.
Yes.
एक और खेमका साहब इसमें एक और चीज है कि वेदर जो लिमिटेशन सीबीडीटी ने प्रिस्क्राइब की है फॉर द पर्पस ऑफ कंपाउंडिंग एप्लीकेशन, whether this power is given by the act to the CBDT for prescribing such limit.
Sir, so far as CBDT is concerned, CBDT can give directions which have the effect of benefiting the SSC.
In fact, that power is available under section 190.
Yeah, but it cannot override the provisions, express provisions of the Act. That is why I said that while the section says 279(2) says that you can file the compounding application anytime during the proceedings. So it can be even at the end of the trial. Now that opportunity has been taken away by way of this circular from me. So in an appropriate case, we will challenge that.
Yes. Okay.
So there is a query from Shubham Rastogi ji, where a return under section 139 subsection 1 has been filed declaring certain source of income. Thereafter, another source of income is discovered in assessment proceedings. Can prosecution be launched under section 277 of the IT Act for wrong verification of income in income tax return?
Now, the question is a little, not clear. That another source of income is discovered by whom? By the SSC or by the department?
By the department, sir, during the assessment.
So the SSC right from the very beginning knew about it. SSC has misdeclared in his returns. So he has made a wrong verification. Not only he will be prosecuted under 277, he will also be prosecuted under 276(c)(1).
Correct.
So there is one query CA Kuldeep Arora has posted on our YouTube. What is the responsibility of an auditor where a company is found to be guilty under Benami or PMLA?
See, now that I'll help you.
Yes.
You see, the question does not reveal full facts. If the auditor abets something, like in the Satyam case, if auditor has abated money laundering or auditor has abated Benami by the company, through his action, which is discernible, for which evidence is available on record, then he can be proceeded against under those acts. But merely because he has audited the balance sheet, he has audited their accounts, and whatever information was given to them did not contain whatever actions, laundering action took place by the company, and he was unaware of it, that was not part of his report, then how can he be charged with abatement? It cannot be. So it depends on the facts of the matter.
Okay. Amit sir, if you want to add something to it.
Yeah.
If he asks, he can always speak to me or Ashwini, and we are always available.
Sure, sir. Thank you so much.
And the point is that that is why I said that we have to act with arm's length approach. Unfortunately, with the chartered accountants, most of your clients become your family members. Over the period, because you have been working for them 20 years, 25 years, 30 years. So you forget that you are not the SSC, you are not the client.
SSC.
You have to always remember that you are the professionals, and the professionals have to work with the arm's length approach. And if you will keep that in mind, no such problem will ever arise.
Thank you, sir.
प्रॉब्लम क्या है, ये आर्म्स लेंथ प्रिंसिपल तुरंत हमें समझ में आ जाता है हम चार्टर्ड अकाउंटेंट्स को, पर वो सुन के तकलीफ थोड़ी ज्यादा होती है कि यार ये तो बड़ा मुश्किल है, आर्म्स लेंथ प्रिंसिपल पे कैसे काम करेंगे यार, ये तो फिर मतलब दैट इज द प्रॉब्लम ये नहीं है कि हमें क्वेश्चन का आंसर जानना है, प्रॉब्लम ये है कि हमें चाहिए कि यार जो आंसर हम सुनते हैं उसके बजाय कोई और आंसर है आपके पास, क्योंकि नहीं नथिंग डूइंग यार, तुम्हारा क्या मतलब, जो मर्जी करो, तुम्हारे को फुल आजादी है, तुम्हारे को कोई कुछ नहीं कर सकता। भारत सरकार का ऐसा कोई सर्कुलर है जो कहता नहीं नहीं ऑडिटर्स को फुल प्रोटेक्शन होगी यार, तो ऐसा कुछ हम ढूंढ नहीं पाए अब तक। रादर हम आपको कोई ऐसी बात कहेंगे जो आप तक अभी को किसी ने नहीं बताई होगी कि आने वाले टाइम में ये जो मैंने डेटा एनालिटिक्स की बात बताई थी, मल्टीप्रोब एजेंसीज की बात बताई थी, इसमें वो शुरू ही ऑडिटर से करने वाले हैं, और जितने केसेस हमारे पास आ रहे हैं उस सबसे पहले एक्शन लेते हैं जो चार्टर्ड अकाउंटेंट्स होते हैं। चार्टर्ड अकाउंटेंट्स उनको मानते हैं जो उनको ऑडिट करते हैं, बाकी तो आते जाते रहते हैं, ऑडिट वाला ही परमानेंट होता है।
तो कोई भी पीएमएलए का, एसएफआईओ का कोई प्रोसिक्यूशन ऐसा नहीं है जहां पर कि कम से कम एक और ज्यादा से ज्यादा 40-50 चार्टर्ड अकाउंटेंट्स और कंपनी सेक्रेटरीज को एक्यूज नहीं है। इन एवरी केस दे आर
वेरी राइट। So we need to be careful. The time has come when we must realign ourselves and learn how to work on arm's length principle.
Thank you so much, sir. I guess all the queries have been answered, and everybody is asking for the PPTs. I must tell everyone that the entire webinar is accessible on our YouTube channel, Sikasa Lucknow. So in case you have any query, you can visit the page and you can see the webinar.
अच्छा, पहले पंकज अग्रवाल जी का खोलना जरा, एक मिनट पंकज जी से हेलो कर लें यार। पंकज जी तो लर्नेड हैं, अगर वही पंकज अग्रवाल जी हैं जिनको मैं
वही है सर पंकज सर।
वीडियो उनको जरा नमस्कार करें। पंकज जी को हमारे गुरुजी हैं और हमसे क्वेश्चन पूछ रहे हैं, तो हमें क्वेश्चन पूछने चाहिए उनसे।
पंकज सर इज लाइव सर।
हाँ जी पंकज जी, आप अनम्यूट करना, अनम्यूट तो करो सर, अनम्यूट तो करो नीचे जाके। यस
हाँ हो गया सर जी। सर थैंक यू सर।
सर देखो क्या है
अश्विनी जी, एक्चुअली आई वाज
Pankaj ji has authored a very good book on Benami law.
Yes.
Yeah.
जी सर।
हाँ, Rahul asked me to give some queries so that it become a lively discussion. That's why I gave.
I am requesting you to give answers of those queries also.
The that I have taken up in my book. I missed that part when you were referring to those queries. Actually, one was that loan and loan amount.
सर इसका क्या करें? शेयर कैपिटल जो आती है सेक्शन 68 की, व्हाट इज योर व्यू ऑन दिस? कि क्या होना चाहिए सेक्शन 68 को? अगर मान लो किसी ने एडमिट कर लिया कि हाँ जी मैंने बोगस ली है और कैश लेके और दिया है काम, एडमिटेड फैक्ट्स की बात करते हैं अभी, तो वो जो शेयर कैपिटल खड़ी है उसको क्या ट्रीट करेंगे? बेनामी करेंगे नहीं करेंगे?
शेयर कैपिटल भी तो एक प्रॉपर्टी है, वो बेनामी हो गई, जो उसका बेनिफिशियल ओनर है आज की तारीख में। क्योंकि दोनों लिम है ना, जो एक मैंने मेरी क्वेरी तो बेसिकली लोन के बेसिकली मैंने बनाई थी कि जो एक ये भी इशू उठ रहा था कि प्रॉपर्टी खरीदी गई और हमने बुक्स में कैश क्रेडिट दिखाया हुआ है और कैश क्रेडिट खत्म हो गई, तो क्या गवर्नमेंट उस कैश क्रेडिट को भी तो सीज कर सकती है, कॉन्फिस्केट, बिकॉज कैश क्रेडिट इज आल्सो प्रॉपर्टी।
या वो भी तो लोन एसेट है, जो अपनी बैलेंस शीट में लोन दिखा रहा है, वो जो लोन डेबिट करेगा वो भी एसेट ही होगी अपने आप में, एक चूंकि एसेट होगी।
उसके वो बुक रखता है नहीं रखता, बट इट इज एन एसेट इन फ्रॉम लेंडर पॉइंट ऑफ व्यू।
Yes. So there is a gray area and serious problem. Which I visualize.
And in this share capital aspect, what I see is that who is the present owner of that share capital? In fact, today in shell companies, what has happened? Who is the ultimate beneficial owner today? Yes. That is to be seen. And the basic gray area is the present owner has paid only 2 rupees worth in his book and he is owning 100 rupees share.
Yes.
So who is the financier of this 98 rupees difference?
Yes.
because nobody has suffered that much loss.
Yes, all these problems will come. Yes. And so, courts are also not going to help unless
provided the
unless seasoned lawyers like Amit Khemka ji कुछ नया हुआ मैजिक कर दें कोर्ट में, वो एक अलग बात है, नहीं तो कोर्ट्स भी कोई दूसरा व्यू लेने वाली नहीं है।
अश्विनी जी, ऐसा है कि अपने जी जैसे लोगों ने जितना बेनामी लॉ को समझ लिया है, मेरे हिसाब से हिंदुस्तान के 1% जजेस ने भी उतना नहीं समझा होगा। Not even 1% judges. You need to give lectures to.
That's right. That's right.
Yes, that is uncharted territory now.
मैंने एक्चुअली रिक्वेस्ट की थी ऑनरेबल जस्टिस मनमोहन सिंह जी से, जो चेयरमैन अभी रिटायर हुए हैं एपीलेट ट्राइब्यूनल से, कि सर अगर आप आ सकें तो वो ही इज आल्सो कॉन्टेम्पलेटिंग टू जॉइन ऑन एनी वन ऑफ द फोरम्स। आज अभी मैं आई कैन शेयर विद द ऑडियंस, ऑनरेबल जस्टिस अनिल आर दवे वाज देयर विद अस एंड ही हैड टू लीव इन बिटवीन फॉर ए कॉल। हम उनको ढूंढ रहे थे ना, को शायद नाम उनका अनिल लिखा हुआ था। He was there with us in the audience. He just and said your presentation is going very well. I am very happy the way you people are educating yourself and others and everybody. So he was there. He is originally a chartered accountant, Dave Saab, and then he reached to and then he retired from there. तो सर एक छोटी सी हम्बल कोशिश तो कर रहे हैं, अगर आप जोड़ देंगे और ऊपर वाले सर्कल में तो अच्छा रहेगा। सब तक पहुंचनी चाहिए बात की क्या लोगों की परेशानियां शुरू होने वाली है इस बेनामी लॉ में, क्योंकि जिस तरह से लॉ ड्राफ्टेड है इसमें जो जेन्युइन सर्कमस्टांसेस हैं उनको भी फैक्टर इन नहीं किया। चलो शेयर कैपिटल वाले मुद्दे को तो अलग निकाल देते हैं, बट अदरवाइज आल्सो जो जेन्युइन हार्डशिप केसेस हैं, जो क्वेरीज अभी आ रही थी अमित गुप्ता जी की सबकी की फैमिली मेंबर इकट्ठे मिलकर प्रॉपर्टी, एंड उन सब केसेस को भी नहीं फैक्टर इन किया है। बोनाफाइड परचेजर्स को भी प्रोटेक्शन का मैकेनिज्म नहीं है। सो आई थिंक किसी फोरम से वॉइस रेज हो, मे बी थ्रू लखनऊ ब्रांच ऑफ चार्टर्ड अकाउंटेंट्स, रूटिंग थ्रू आईसीआई और व्हाटएवर मैनर, कि आप जो इसमें अमेंडमेंट की जरूरत है वो आने चाहिए। बहुत सारे एरियाज हैं इसमें। जी सर।
Definitely, sir. We'll look into it. If we have any other query from anyone. So I guess all queries have been answered. And
thanks to the organizers. Thanks to Lucknow, the city of Tehzeeb. And I feel that please keep safe. Please follow all the instructions of the government, of the authorities. So that should be also our duty right now. And please keep yourself positive by these kind of interactions. You are doing wonderful job by keeping positivity alive by these kind of interactions. And thank you so much. Thank you, everyone.
Thank you so much to all the speakers, panelists, Khemka sir, Ashwani sir, and Das sir, who have imparted us with their knowledge and shared the insight of the Benami Law and PMLA Act. We are also thankful to all the participants who have joined and asked a lot of queries. Entire program is available on Sikasa Lucknow Sikasa page, YouTube channel. It can be viewed later on also. Thank you so much. Thank you so much to everyone.
Thank you.
Thank you.
Thank you, everybody.
Thank you.
Thank you.
Thank you, everybody.